Yes. इससे चलाओ कर तो. Yes.
Wait a minute. Just wait for your turn. Adjournment request from item number 1 to 21. From item number 22 to 25, adjournment request.
Yes.
From item number 26 to 40, any adjournment request?
पीछे का ऐसी वैसे चलाओ.
Please, your lordship, I beg to mention item number.
You have to be louder bit.
Lordship, I beg to mention item number 38, lordship.
38.
If I
Yes, what
circulate
is the
with
matter? What do you want?
Adjournment slip, lordship.
Adjournment slip circulated. All right.
5th May.
If me, much obliged, lordship.
Yes.
They mention item number 42 of supplementary.
42 of the supplementary.
For
What is the
withdrawal,
supplementary list?
It's because the matter already become steel structures.
What is your name?
A high.
Hmm?
Of M. Ahmad.
Mr. M. Ahmed, learned advocate for the appellant, seeks permission to withdraw this appeal. Dismissed as withdrawn.
Pleasure. May I please?
Yes.
To mention item 41, my lord, I would like to withdraw this.
You are Mr.
B. Protect.
Mr. क्या नाम है? B. Purkayth. Mr. B. Purkayth, learned advocate for the petitioner, seeks permission to withdraw this application. Dismissed as withdrawn.
Please, your lordship, I pray for listing the rate appeal on Thursday, my lord.
All adjournments over.
Adjournment.
Yes.
I pray for listing of a rate appeal on Thursday, my lord.
On Thursday.
On Thursday.
What is so special about
It's some
Thursday?
urgency because lordship, an incident committee has been lordship constituted for the 4th time. Lordship, and 13 is the last day. Otherwise, they'll start with the
No, committee for what?
lordship under the POSH Act, Prevention of Sexual Harassment Act, lordship.
So where is the problem? I mean, can you dispute the constitution of the committee?
Lordship, yes, because it's for the 4th time for the same allegation, my lord. It has been constituted.
Ah.
Previously, on 3 occasions, they have lordship.
All right,
also
Thursday.
Deeply obliged.
Any other request?
बोल देते हैं, but I must say Thursday this bench would not be available. It will go before any other bench. It will not be available. This court is going to Nagaland for.
38.
All right. Yes.
Your Lordship, item 36,
Yes.
I was informed that the respondent is mentioning the matter. In this matter, the Advocate General of Nagaland appears.
They have yet not mentioned.
Yes, Your Lordship.
If you have to mention, you can mention. Oh, he is there to
Here
mention.
for the petition, madam. Respondent number 6 informed us and took our consent. also.
Item number
36, madam.
36.
Respondent number 6 took our consent.
36 adjournment slip has been circulated. So we will.
Obliged, obliged.
Adjournment slip has been circulated. You want a special date? Any?
Your Lordship, it can be in sometime in April, after 22nd April.
All right.
28.
All right.
28 4.
Obliged, Your Lordship.
And in all such matters where adjournment slip has been circulated, but there is no mention today,
Yes.
adjourn it to a comfortable date
Yes. Lord.
according to the calendar.
Then one last, 33 to 35.
Yes.
From 33 to 35.
Or is it the same matter which deals with
7 May.
ILP and all?
No. This is challenging.
7
No,
May.
Your Lordship, this is a service matter.
Okay.
This is different. Yes.
All.
33 to 35 on 7 May. Daily list for orders item 1 to 19, 1 to 20.
There's something wrong here. Yeah, so this position is wrong. I can't see the advocate. So something is troubling me.
This is.
You remove that. Has the setting been changed?
That is in something different in that code. no?
Yes.
May I just point out, Lordship, this is the matter regarding disability pension. This, the issue is before the Honorable Supreme Court, and by order dated 19/2. All these matters have been directed to be listed on 23/4/26, Lordship.
उसमें है ये अंतिम में provision to appear
Keep it after. When is the next date in Supreme Court?
23/4/26, Lordship.
23/4. So we keep it in May, sometimes in May.
Also applies.
All right.
Lordship, may I point out one thing, Lordship? In this series, Lordship, item number 1, 3, 9 and 13, the dispute regarding the disability pension is not there. The main dispute is the date of granting the rounding off. That issue has been, yes, those three, those can be separated and already.
No. We'll decide. Now, date or disability pension, all are, all fall under the same
But these
head.
issues has been already settled.
We'll see.
Not,
You never know how the law would evolve.
not.
We do not know whether you
Yes, I
are
was-
at all entitled
Yes, not.
or you're entitled from whichever date, the presumption, as in Dharmveer Singh.
Not,
So let us wait for it. Let
Yes,
us
sir.
not jump the queue.
not.
Okay, in view of similar issues arising for consideration before the Supreme Court, these writ petitions are adjourned to give a date on May.
May. 13 May.
Obliged.
इसमें क्या है? 20.
Item 21.
Say, awaiting the service.
We have not taken steps for the regular sales.
Awaiting the report regarding service of notice on response number 3 and 4, the matter is adjourned to still service.
We have not taken steps in the other mode.
Notice is delivered.
Yes,
Very easy.
you're appearing. All right,
Appearing for respondent number 3, Lordship.
all respondents have appeared.
Appeared, no, 3 and 4.
All right, in view of all respondents having been noticed and they having appeared through respective counsel, the matter is directed to be listed under the heading admission on give a date.
4th May. Supplementary list, item 43.
Third के लिए है.
Yes,
Withdraw.
you want to withdraw?
Yes, Lordship.
You are DJ Boro.
Yes, Lordship.
Mr. DJ Boro, learned advocate for the applicant. Now, what are you withdrawing? The entire appeal or the IA?
Entire appeal, Lordship.
Entire appeal. Mr. DJ Boro, learned advocate for the appellant, seeks to withdraw the appeal along with the interlocutory applications filed therein. Dismissed as withdrawn.
Item 44.
Your Lordships, this is a delayed condemnation petition, Your Lordship. It came on 2nd of March, and on that day we were directed to take steps upon the respondent. Your Lordship, while taking the steps, it came to our knowledge.
What do you want?
Your Lordship, there are certain clerical errors in the 2 copies which have been presented.
We are asking you, what do you want? You want to withdraw the petition?
So, Your Lordship, we seek leave of this honorable court to make the changes with the registry, Your Lordship.
Already 22.
2 paras in the second copy are not there in the first copy, Your Lordship.
Just a minute.
हमारा देखिए 2, 3 का.
एक बार check करो. 2-3 देगा. Issue notice to Solar on steps. Now, we had fixed it for 22nd of April.
Your Lordship, but we were not able to take steps because the 2 copies which are there before your Lordships are slightly different.
Then
paragraphs.
what do we do then?
Your Lordship, if your Lordship pleases, we can make the change, we can file the correct second.
No, we
copy.
will not allow you to do that. After you have filed, we will not permit it unless it is vetted by the registry. We don't know what will you place. I mean, this is no confidence on you, but then the system, it can work otherwise. Withdraw the application, file a fresh application, will permit you to do so.
Okay, your Lordship, we went to the registry, the registry saw the differences and they suggested.
No,
that
no.
we take-
Then that's a ground for us to dismiss your application straight away. We don't even look at the contents of the application if it is for condonation or other things unless the delay is too big. Take a call, withdraw this, otherwise we'll dismiss the application on merits. This is not condonable. 2 different copies, 2 different contents before 2 different judges.
Just one fact is there, 2 paras are different. Your Lordship.
If it is not, withdraw this, file a fresh one. Take instructions from your senior. Are you holding brief for somebody?
No, Your Lordship, my senior R.K. Bhatra is.
So therefore you are holding brief for your senior, no? Who is he?
R.K. Bhatra, sir.
So he would not be unhappy to receive this news that you have withdrawn. Would you like to take instruction?
Yes, Your
Tell
Lordship.
the court was angry. Court said that this could not have been, this should not have been done, but the court is indulgent. If we withdraw, we can file fresh petition. We will do that. Ask your senior and then come back to us within an hour.
Yes, Your Lordship.
We remember the old days where the senior would get angry at the junior. Why did you withdraw? Why did you not wait for me?
For admission, item 22.
एक बार dismiss को जाओगे, just के chamber में से चला जाके बोला सर ये
Which item? Yes.
Appearance by the forest department, Lordship. I am for the private respondents.
Who appears for the
appeal by the forest department.
appeal has been filed with the forest department?
Portacore appears normally.
वो पैसा ले चुका है 50%, पूरा सब करने के लिए कहता है 50% ले चुका है 50% ले चुका है because it lapsed. तो उसी को उसका same provisions है. Nobody appears on behalf of the appellant. The counsel for the respond number?
Respondent number, Lordship.
You don't-
1.1 to 1.2.
Respond number so and so is present. A private respondent is present. Let's re-notify this case on, give it in May. It's not there where.
Obliged.
6 May. Item 23.
Yes, Mr. Board Pujari.
Been engaged by two persons who are substituted. Original petition was died and substitution was allowed by the minor appellate court. Respond number 4 and 5 have been engaged.
Yes.
This is an appeal by the state, my lord, against the judgment and order passed by the honorable single judge. So the factual matrix in brief is that, my lord, way back in the year, my lord, in the decade of 70s, my lord, certain proceedings were drawn up under the Fixation of Ceiling Act of 1956. Whereby, my lord, that act mandates, my lord, that if there is any excess land found in favor of any person, other than, my lord, over and above the permissible limits, then the state authorities.
That's all right. That
Yes.
ceiling law.
Yes, my
Tell
lord.
us what has happened.
Now, my lord, those proceedings were drawn up and finally, my lord, the writ petitioners were, my lord, the records were sought to be corrected and the writ petitioners were sought to be evicted. Now, at that stage, my lord, the writ petition came to be filed before this honorable court. Now, during the proceedings, writ proceedings, my lord, an affidavit was filed on behalf of the collector, whereby, my lord, it was brought on record to the effect, my lord, that by efflux of time, by the due passage of time, my lord, lot many persons have came into occupation over the part and parcel of land. And it was the categorical stand of the state authorities, more precisely by the district collector in the affidavit, that the writ petitioners were never in occupation of those part and parcels of land. Nonetheless, my lord, the honorable single judge held that the sealing proceedings that were held, my lord, way back in the year of 1972-73, my lord, those were not in conformity with law. So therefore, my lord, the sealing
No,
proceedings
all,
were set
all
aside.
these aspects of the matter, Mr. Board Pujari, we'll look at some other point of time. Tell me one fact whether section 7 notification was issued.
My lord, we had pleaded before the honorable single judge that, my lord, by that time, my lord, all the records were not available.
Can this be
That,
the ground?
that was the only difficulty. I
Can
take
this
it.
be the ground?
That was the
Why
only.
do we
difficulty.
interfere then?
Because at that point of time, my lord, the district was, my lord.
And like the Bihar sealing laws, is there a ban now restarting the proceedings? Or is there a provision for restarting the proceedings?
ये करने की भी permission दी revenue officer agreed to the
Now,
That permission has been accorded to you by in the
yes,
interim judge.
yes. Now,
Go ahead.
paragraph 4.
Go ahead.
difficulty is that, my lord, in those part and parcels of land, many governmental institutions came to be set up, number one. Number two.
So who is asking you to vacate? You start the proceedings all over again, but section 7 notification is a must. You know,
Absolutely.
how, see, they will have to argue on delay.
वही बात है।
Yes, Mr. Borba.
76 and 2000.
My lord, they.
I mean, what is this? You pick up something as if it's a low-lying fruit and you come back after 40 years
My lord,
asking for something,
my lord, I am here to.
stabilizing the entire thing.
I am here to defend the judgment of this learned single judge, my lord. Findings with respect to the question of law pertaining to the, my lord, Sealing Act of 1956.
And this application is, this appeal is admitted for hearing. List the matter for final determination on times in June. Give a fixed date. Mr. Borpujari, look about this. I mean, the permission which has been granted to you under the judgment, if you can go ahead with that.
No, my lord, matter may not be that simple, my lord. Will allow me.
We will allow you.
So
That date.
the
Actually,
record will
next.
have to be there, my lord. There was an order by the, my lord, division bench, earlier order.
All right, we'll see it on that day.
They
4th
will have to
June.
produce the records.
We are already protected in the interim, my lord, if that can be. accepted.
Interim protection, if any, in the meanwhile shall continue.
And so, like,
My lord,
4th of June.
maybe a bit early, my lord, because we have been rendered entirely landless. The question is, assuming, even irrespective of.
For 23, how many years were you landless then?
Question is, my lord, even if
We will, the balance of convenience is in the favor of this. state.
government
We
has
follow-
not shown us the
All right,
retrievable.
Mr. Barbara, we have fixed a date. If you have waited for 28 years, 29 years, you can wait for 2 months more.
No, my lord, we once came in 2009 before this court, my lord.
What?
We came earlier.
After 76,
Earlier-
you came before
No,
the
no, no.
authority in the year 2013.
Next.
My lord,
Follow text.
everything was without publication of a notice and behind our.
We have followed that. We have followed that. Therefore, I mean, we have asked him that question.
Can
The
it be
difference-
sometime, can it be sometime in May first week, my lord? That is my little plan.
All right,
First week.
May last, not first week.
Yes, sir.
26 May. Item 24.
7 months. And what is your explanation, Mr. Borpuzari? This is the way your records are kept in the state. You create problems for yourself, you create problem for judicial authorities, you create problem for others.
I cannot travel beyond the records.
You can't travel beyond the records, but this speaks badly of your record keeping, status.
They are the custodian
And
of
it's very
records.
easy. You know, we have seen such matters, appointment matters. We have no records, sir.
They are the
And
custodian.
persons are in service for last 20 years. What is this? And there has to be a semblance of,
They are the custodian of the records.
Our
Mr.
explanation,
Borgora, he's already in problem. Why are you unnecessarily? See, we understand. After so many years, they come out with some notification, something that this application was never decided.
our only and solitary explanation was that, my lord, at that point of time, it was one district, my lord, Kamrup. Kamrup and.
That explanation,
bifurcated.
is that explanation capable of being bought by the landoholders? No.
So we are
Dekhte hain, we will see. And all that land you have consumed for making government buildings.
not only government buildings,
ये
but
तो redistribution के लिए होता है ना?
correct, my lord, but.
So have you distributed it to others?
Yes.
You have issued parcha.
Yes, we have it to Patta. They are the absolute owners now. Now, a decree,
How will we notice them?
No, they are not parties.
No,
How will we do that?
my lord, my argument will be the government was not vested, the land
You
was
were
not
right, Mr. Borbora, when you said
vested to
that.
the government. So government cannot vest it to others.
That's correct, but somebody has been.
That will be a
Can you hear the court?
that will be a point of argument, my lord.
Can you hear the court now?
Yes.
So that's what, Mr. Borbora, you were right when you said that it is not so simple. How many persons have been given parcha out of these 250
Nobody
acres?
knows.
more than 100.
So without issuing notice to them, do you think we'll decide it otherwise?
Now, once the affidavit.
That will have to be seen.
my lord, once-
That we will have to see.
That will have to,
You come out with an answer.
we'll have to see, my lord.
If
My answer is, my lord, they are totally strangers. If the government is not legally and under the rule of law
you
vested,
say so, but we will not
No.
accept this. If for 30
No,
years
government-
they have been living on that land, we will not throw them out.
number one,
Without
government.
hearing them.
If the government, land could not have vested to the government,
We have followed-
government in turn could
We
not.
have
vest
followed
it.
that technical argument.
That is right. No,
We have followed that technical argument, but the question is that if somebody has been staying there for 22 to 30 years, we are not going to dispossess them without noticing them.
from records, they have failed to show that.
What?
From records, they have failed.
No,
to show.
therefore, we have given them, you please
Let
show
them
us
show, let them
how
show,
many have you distributed?
Yes, it is already there, my lord.
All right, on the next date, you come
let
up.
them show the names.
We will issue notice to them. We can't pass any order otherwise. But you have created problem for yourself
That is true, my. I have
to the,
take it.
to
I
the
have to take
unnecessary
it.
advantage of these people who had excess land and that was taken away.
I have to go down. I have to go down.
तो उन्हें And on that ground, we will interfere with the order. And therefore, the necessity of giving interim protection.
The judgment is under stay already.
Don't look dazed at us. As important the party would be those who are invisible here. Yes, we are permitting you.
For the petitioners before the single right? In fact, my lord, those persons had approached the court seeking an impeachment. Then when they realized that that cannot happen, my lord, they themselves withdrew.
Why?
My lord, there are orders to that.
Why it cannot happen?
My lord, because ultimately, my lord, the state, though they have shown the record of right, there is no specific order granting a settlement. In fact, there are annexures.
So therefore, if they don't show their bona fide, we will consider them to be persona non grata. But with the statement of the state in appeal.
That's not correct, my lord. At least from the record, my lord, they have
Let's see.
themselves said that there has been no complaint.
Where is it recorded?
Lord, in the circle officer's order.
Has it been taken into account by the single judge?
Yes, my lord. All of that is on.
All right.
Authorized occupants.
Those are
We'll hear on that date.
a huge parcel.
That's what I am saying.
Clear on that.
Unauthorized occupants, my lord, strangers.
Please don't be harsh. So harsh without the court deciding it. Unauthorized, persona non grata. We are granting interim stay in interim protection, if any, shall
The
continue.
judgment is already under stay.
Chaliye.
Lordship, lordship.
Next.
Item 24.
कहाँ से लेने का चाहिए? 30 साल के बाद?
26.5 वाला confirm.
Yes, madam. Pursuant to the
What
last
about
order,
the school?
yes, madam.
Ah.
Pursuant to the last order, madam, I have communicated with the department, and in fact, I have received an instruction. I also annex the
Well,
my
you had plenty
communication.
of time. Why don't you put all these on record? Huh? You should put all this on record. Urgent consultation and instruction in terms of the order. Please read that. If you have a copy. You have a copy of that?
Yes, madam. Yes,
Please
that
read.
is my communication, madam. Instruction is that.
Read that. No?
Yes, sure. Yes, madam.
Whatever you wish
Yes, madam.
us to look at.
With reference to the subject cited above, it is to inform you that the Honorable High Court, by order dated 23/2/2026, passing PL number so and so, has been
Yeah,
pleased to directly understand.
No, no, you read
it
that.
is to- ये ठीक है, this communication.
Please communicate.
Doesn't matter. हम लोग समझ जाएंगे. ये क्या? Yes, continue.
Understand to consult the Commissioner and Secretary to the School Education Department with regard to the effective implementation of Section 12(1)(c) of RT Act.
Come to second paragraph.
During the course of hearing, the Honorable Court expressed serious concern and dissatisfaction over the manner in which the provision of Section 12(1)(c) are being implemented in the state. Despite the online portal having been made operational for the academic year session 26-27, it was found that there is virtually no enlistment of unaided schools for the said session, thereby frustrating the very objective of the statute and depriving eligible and needy students of their statutory entitlement. The Honorable Court has observed that the state is under a legal obligation to ensure meaningful and effective implementation of the mandate under the Act. The absence of clear direction compelling unaided schools to register on the portal and reflect available vacancies has been viewed with concern, particularly in the light of impending admission session. The Honorable Court has indicated that any continued inaction or lack of effective compliance may necessitate judicial intervention. Further, the Honorable Court has sought specific clarification regarding the rejection of certain schools from the registration on the LS ground that the medium of instruction is not vernacular. The Honorable Court has.
We have followed.
Yes, madam.
We wanted you to hold consultation. You have done that.
Yes.
But the answer is, we would not like you to put on record. We'll take action against the officer. Don't read out the answer.
Yes, my lord.
Otherwise, MS Verma would ask for
In fact,
contempt notice to be
I have served a copy of the
You
instruction.
committed a mistake.
Right.
Committed a mistake.
Is a privilege communication given. You should not-
You should not have done that. Otherwise, let her now say this is contemptuous. We would be perfectly justified in issuing notice to the officer to answer to the charge of contempt. He doesn't understand. He is an IAS officer. No, ACS officer.
This is IAS officer, my lord.
No,
Whoever is ICS or whichever, he doesn't know what he is writing to his lawyer. Of course, it's internal communication.
don't show it first.
Don't show it to us. We will not look at it. Send that to him. It's all trash. Don't stoke, we wish to be as cooperative as possible. Smoke the fire. You're not asking for any personal privilege. Are we?
No, my lord. Absolutely not.
No, they meant it not wrong. They will have to give
You're,
you the answer.
hello. Issue करते हैं notice इनको. What do you want? Should I call him?
Better to call, my lord, because since I have already communicated with the department and I have spoke to them also, my lord.
This is a mandate. They can start the.
Can this ground be taken?
No, my lord.
You understand this? Why did you show it to us?
He is also compelled there in listening to you.
Why did you show it to us? And he would be perfectly justified in saying that this was my view. I have told you, you should have reframed it before the court. We don't ask you to just verbatim, reproduce what we say. You have also not acted responsibly, Mr. Katniar. Urgent matters can't wait for elections. No, this is not something which would be prohibited because of the election date or model code of conduct. This is school admission.
Direction because in terms of that, उनको avail करने के लिए online.
करेगा नहीं, क्या करेगा? The order will not be executed. The whole consultation again. Do we record that the response is bad? We don't want to do it.
Yes, my lord.
What yes? We don't want to do it. Most of the times we find what yes. You say yes against your client. Is this? I mean, perhaps he's not
And
understanding.
Mr. Phataniar, go to the commissioner and secretary, not this kind of joint secretary.
In fact,
Let us have a response from the Secretary of Education.
there was a conference call also, my lord. I have, in
ये
fact,
भेज ही देते हैं.
but-
Election, he will understand what election is. Now this issue has become irrelevant before us. Now we must deal with that officer. What has he thought of himself? Just that we don't want to do it for the reason of there has to be a synergy. That doesn't mean that he would forget what whom he's addressing. Showing a typically flat mentality. Secretary. Who is the Secretary of Education? The highest person. We'll tell him
Secretary.
that this is not the way. This officer must be removed from that position. We are not asking, we'll just show it to him.
secretary, my lord, commissioner and secretary,
We-
Mr. Narayan.
we don't,
And secretary or additional chief secretary is there.
no,
Commissioner
Mr.
commissioner
Khatniar-
and secretary, my lord.
Mr. Khatniar, the
Yes.
difficulty here is that I am here to save the lawyers also. This you should not have shown us. This is a communication between that officer and you. You brought it to us, our notice, without looking at it. आपको दिखाना ही नहीं था. आप कहते कि वो communication, I am not satisfied. Now what do I say? What will you answer? What you were supposed to put it? Have you put it on record? Then we are asking you, if you have done that, if you are so adventurous, put it on record, then we take action. Put it on record, we'll take action.
By that very.
Let him file an affidavit. What do you do? Mr. Khatnia,
I'm sorry,
careful.
madam.
You are playing with live fire. Live wire, so to say. Not fire, live wire. You get hurt, you get burned if you don't think. We are only maintaining this, this restraint for the reason that we don't want to put the state in chaos. If you want to see the ambit of the powers under 226, we can show you.
That I know, that I understand, madam. I'm not.
That's what you should have been careful.
Commissioner को बुलाते हैं, WhatsApp.
Hold consultations again. Say that you are trying to do, or if you can't handle that, ask the commissioner to be here. We give you one more opportunity.
Yes, madam.
The purpose is not to see the face of the officer. The purpose is to ensure that this policy is implemented. Very, the communication is in bad taste, number one. Number two, it shows inexperience in handling matters. And number three, we are unhappy that reading this, you did not realize that this will displease the court. And you just handed it over, 2 copies, 3 copies. I have also worked for the government for at least only 4 months because it was impossible for me to work. But then we vetted these communication, no? You just can't pass on everything. Now what do I do? If I say anything, it goes against you.
Yes, madam.
If I say anything, it goes against you. You have not handled it properly.
Okay, sir. इन लोगों को ये client को ये नहीं करते हैं. Post करते हैं. यही है.
I think, can I request the Advocate General to be here? Ask him.
He's here tomorrow.
But you've disturbed us by filing that communication, by showing to us that communication. You should have been more careful, Mr. Khatniar. Now, I don't need to talk to those officers who do not know. You're an officer of the court, no? Should you have given that letter to us? Should you have given that letter to us? You're holding the, I mean, you are a responsible senior government advocate. Forget about your department. This aspect has to go away from our mind to focus on the other facts of the other case. Mr. Khatniar, we are not happy at the way you have handled it. But I'm not concerned about officers. Next time, just hold conversation. Let me not express any further. You know, it'll spoil the proceedings of the court in other cases. Just go withdraw this as if we have not seen this. Take it away. Tell us next week. Let this matter, or else ask the learned Advocate General to be here. We will tell him that this is how your officer is doing.
I convey him, Malad.
You will convey, but why did you give that letter to us?
Sorry, Malad.
We are not calling the secretary only for the reason that you fall in suit as a law officer. You must know how to, you have seen funambulists. You know what a funambulist is? Tightrope walker. Lawyers are tightrope walkers. You have to face your client, the government, the might of the state, and the wrath of the court. You have to maintain a balance, Mr. Khatniar. That balance is not required to be undertaken by MS Verma for the reason that she is a private lawyer. She is answerable to her client, and of course, to some extent, to the court. We give you one more opportunity. At least come up with a response which does not displease us like this.
Yes, Malad.
I had made a promise to myself that I will not lose temper here in Assam, but you have forced me to do that today. Forced me to do that today.
16 को रखते हैं.
This is matter on 16th of No, they are not interested. We should have shown that.
No, he should not have shown that. But that is their stand.
We are still not ready to believe that that is the stand of the education department. This is a foolish communication of the officer. and not a responsible officer. We are still not ready to believe that the education department is having this stand.
You cannot have, because the mandate of the statute.
Talk about other difficulties. So we should shut down the court because the elections are around the corner. Are you suggesting this?
No.
The more we think about it, the more angry we become. Forget it. List this matter for further consideration. We'll do it with an even mind. I mean, not today. Today it'll all be against Mr. Khatniar. Let us not be very harsh to him. Let this matter come up for consideration on, give a date after 2 weeks. Withdraw this, tear it out, burn this, and then say whatever you wish to say. We will have it in show. We'll have it.
27 March.
23rd,
27.
27th, 24th.
Even the person who has been referred to in this reply, if he comes to know about it, this officer would be sacked. Tell the officer.
I'm sorry.
24th.
We have just been lenient because of you, because of an advocate, and not for any other consideration.
Extremely forward.
Item 25.
Well, the person to Lordship's last order, I could file the detailed affidavit yesterday. Now, the detailed project report, tender document, work order, everything I have annexed.
You have filed.
We have filed yesterday.
When have you filed?
Yesterday.
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 Who appears for the petitioner? Very well. So that would be, have you served a copy to him?
Yes, no, but we have given.
Nobody appears on behalf of the petitioner. The affidavit, as directed by this court, has been filed by Mr. Nath, learned senior government advocate. Let this matter come up for consideration on. We give 2 weeks.
Well,
You have done everything.
the DPR, work order, everything we have given, 6
All right.
months time is for the work. Malad. The work is going on, 25% has been done. The work.
Let him be here, then we close the.
Lordship.
1st April.
Lordship. Malad.
Timing matter 44.
Yeah, what do you want? You should have given instruction to your junior.
I thought I'll reach on time.
You should have given instruction to your junior. She handled it very well in the morning. So we had suggested to her that please seek instructions from your senior. This is not possible to be amended.
Exactly.
This can be a ground for dismissing your application straight away. Not only IA, but everything on merits. You have not been careful. So better to withdraw with the liberty to file another application. Okay, after some arguments, we put it on you. Mr. So-and-so learned advocate seeks permission to withdraw this application with the liberty to file a fresh application for condonation of delay. Dismissed is withdrawn with the liberty of aforesaid.
For hearing, item
We are
26. Sorry.
absolutely comfortable when you understand your folly and ready to amend it. We don't have any objection. But then if you insist for something which is not possible, then we take a tough stand. Otherwise, we are here to help out all of you. Correct?
I'm deeply of that.
For hearing, item 26 to 29.
Yeah, please, Lordship. Lordship, in item number 28 and 29, writ appeal number 270 and writ appeal number 292 of 2017,
Yes.
Council AK protester is having an unprecedented and unforeseen difficulty. So,
No, no. But this is an old matter, I suppose, 2017.
17 matter law.
Mr. Mishra is appearing in this matter.
Yes, my lord, I am appearing in item number 27.
This is mentioning in item number 28 and 29, some unforeseen, unfortunate circumstance where he cannot
My lord,
proceed with the case.
my
So
lord.
I think we give, when do you want it?
After one,
Huh?
after a week.
After a week. Mr. Mishra, is that comfortable for you?
My lord, 16 will not be comfortable.
Oh, no, you give us your date. Today you're prepared.
My
The
lord,
matter is being
19th,
adjourned for other matters.
19, my lord, this will not also take much time. 19, if you're convenient, your lordship.
19th of March.
March. Or any date, my lord, after that.
Election of 2011.
Just a minute. Just give us 2 minutes.
My lord, my lord.
No, but SI post को non-existent कर दिया था वो. कहता है कि ऐसा कोई है ही नहीं. Then what happened?
Then who said selection set aside कर दिया as per the
Respondent. Respondent. One, and then four, five, four, these should be 4, 5, 6, 7, respondent 11. Last one.
These people are working.
No, what about this sub-inspector's post, Mr. Mishra?
My lord, it's a cadre post.
No, it
And
says
there are over,
how is the
Well-
single judge held that it is a non-existent post? It doesn't follow any
my lord,
case.
my lord, see, if your lordship wants to proceed, I can show.
No,
There are,
just-
there are, my lord,
it has sparked some interest in us that if you're trying to have something of 2014,
yes.
something about which a judge of this court says that this post doesn't exist. Scrap it.
My lord, the learned single judge said that and set aside my appointment of the appellant for whom I appear. But in the next case, he left it to the government, remanded the case back to the government, and did not interfere with that.
What
And
is
there are
the- and after this 2014, did
We
they
are not-
apply? Did they come out with any other notification, advertisement, or something?
no. My lord, the post of sub-inspector SI is there, and it's an admitted fact that in Assam Education Service Rules 1982, SI post is a feeder post for promotion to the post of DI, Deputy Inspector of School. With
That
the
we
cadre.
understand. That we
Yes.
understand.
And my lord,
Despite the erosion
there are
of the
over-
curriculum.
there is a resolution. There is a resolution of 1951. The exact date is 19th of March 1951, which says
Mr.
that
Mishra, Mr. Mishra, let me tell you, we will
Madam.
not get into those issues here in appeal, especially if this is an appeal of 2017. We
Madam.
will use our judicial calendar to just sort out thing whether grade pay stipulation is necessary, whether it is justified. That's all.
My lord, your lordship will have to see whether these are cadre posts or not. The first question.
Exactly.
If
See,
the-
we have followed it.
Yes.
Mr. Mishra, even if we admit and even if you are able to demonstrate before us that this is a cadre post under the service rules, under the teachers' rules,
Yes.
whichever rules are prevalent.
Yeah.
But then that is a feeder post, and for that feeder post, you consider teachers. So here, by this amendment in 2014, they brought a grade pay classification that anybody who has received a grade pay of 3,300 would be eligible. All right, we'll see why piecemeal. All right, we'll. As prayed for some of the appellants in these cluster of appeals, let all these cases be listed for final determination on. We keep it sometimes in April, if that
My lord.
suits you. First week of
Yes.
April.
My lord.
Before. So
Yes,
I
ma'am.
think it's Tuesday, 7th of April.
My lord.
Item 30 and 31.
Selected candidate appointed pending finalization of the service rule.
Mr. Bhuya, where are your judgments?
Yes.
We are absolutely uninclined. The father says in his defense witness that my son was born on the day of
Yeah.
on Bihu,
Bhogal
Bihu, Bhogal Bihu,
Yeah.
Bhogali. That is not date specific, it's religion
Yes.
specific, number one.
That's true, right.
And a person who himself under 313 statement says that he's 18 years.
remember that.
Where is the supporting document? What document? You have not studied even in a basic school, the last
Absolutely.
attended school.
Absolutely.
So we disagree. It's a shield which you're trying to use for delaying the hearing. Not you, your client. Mr. Bhuyan, don't
Yeah.
take it anything personal.
What I'm on, with regard to the law, in a juvenile conflict with law, if there is a situation wherein this law has been
I
made
think
for a
we
purpose.
will dismiss it straight away.
My
because
lord, may I
It
make
does
my,
not inspire confidence.
my lord, may I make my submissions, my lord, may be reflected and dismissed, my lord, I have nothing to say with
All
regard to
right.
this. What I am
आइए दीजिए.
that this law has been made for a purpose, considering the ground relative.
Show us the law,
Yes.
especially 2021. What is that case? I forgot. I had told you on that day.
Yes, my lord, I have brought
Well,
my
I have
particular
given
law
the
also.
list of books, my lord can have.
My lord, what I am on.
We are, Mr. Bhuyan, just to cut short your argument, we
Yes.
are not in dispute that this could be raised at any point of time.
Yes,
Correct. There can be no two opinions about it.
my lord, what I'm on, not on that.
No. Here are formulations first. Now it can be done anytime.
Yes,
Appeal, revision,
Yes,
any stage.
yes.
Two, only in the absence of the listed, materials
Yes.
on which determination could be made under Journal Singh or Section
Yes.
94 or whatever,
yes,
then one could ask for the medical assessment.
yes,
But for that also,
yes.
it could be reopened only if it is satisfactory, only if some foundation. What kind of foundation is this? Does he say that he was born on so and so date? Bhogali Bihu, the dates are not fixed.
My lord, what I am submitting with all respect to this court, my lord, what I am on, when the legislature was making this law with regard to juvenile, my
Have
lord.
you brought V. Sriharan, Union of India versus V. Sriharan 2021? I have forgotten my criminal law.
Yes, my-
2021 SCC online SC 479. And there were other judgments later. In fact,
Yes.
my orders also you'd find where I have allowed.
my,
But
absolutely.
where is that? We are not finding any good ground. There's no anchorage here. Where do we stop?
My lord, I'll come to that.
That means any person coming saying that we did not, where was your application filed before, which was rejected? When did you know it? At 313 also, you make a statement that on that day. Yes.
Item 37.
Give me the pen, sir, with it. No, not 37. I've got a 30.
Sorry.
32.
Item 32.
Pursuant to the last order dated 29/1/26, I have got the instruction, my lord, perhaps it's not adequate, I would not like to place my lord. So will give me further 3 weeks time to have the instruction.
Skeptical of placing the instructions they have what happened to Mr. Katariya.
Don't
No, if
fear.
perhaps, my lord, they
Every
could follow
case,
the court
every
order.
communication is not of the same honor.
My lord,
Don't worry about it. We were only discussing,
I
at
understand.
times we feel constrained.
My lord.
And it is only for the purposes of, because this is a family.
Lordship.
We protect our advocates.
Lordship.
I have received the same treatment from the judges when I was a lawyer. Therefore, I am very, very careful in passing any order which would have an adverse impact on one of my advocates. I'll be harming myself that way. So that is what restrains me from passing orders. Many a times, harsh orders. That's the only concern. So you want some time.
Sometime, my lord. They could not follow the purpose of the order, my lord.
As prayed for on behalf of the state by Sri B. Gogoi, the matter is adjourned to so and so. I think you don't have
That
much.
notification has been made prospective, my lord. In between, my lord, there are certain persons have been.
No, we had asked only, if we remember correctly, we
Yes.
had asked only for that. What happens prior to this notification? You must, this way or that way, you have to decide. We are not directing for anything. We understand the financial implications of it. We will say whatever is possible, but then you are answerable to people, no?
Lordship.
We are answerable to law, you are answerable to people.
Lordship.
So you will have to take a decision.
Lordship.
23-4. Item 37.
Yes, Mr. Manik.
May it please your lordship. My lord, strictly speaking, yes, I am at fault. My client is at fault.
Okay, well, you're on a back foot right from the beginning. अब बताइए. Why? Why are you on a back foot before opening the file? क्या है? We have not seen. Hearing matters, we would hear from you. What is the matter? Why are you reluctant? Why are you hesitant? Tell us. क्या है?
The issue is, there were trademark,
अच्छा, क्या है?
there were trademark entries.
Louder.
There were trademark entries. Am I audible?
Trademark entries.
Trademark entries
Red mark entry.
against my client, who was a structure feature in the Indian Air Force. That's a quite lower rank. And this led to a situation of warning and alcoholism continued, albeit on the lesser scale, but good enough to get an entry. And eventually, he qualified to be a potential, habitual offender. And thereafter, he was issued show cause notice, he replied, and he was cashiered, if I may put it that way. We moved the Armed Force Tribunal unsuccessfully, dismissed from service before your lordship on 2 counts. But I firmly believe that a person may be offered an opportunity to say something, but if he says something, that should be considered and acted upon. Here, actually, his defense was not considered, number one. If considered, what would happen is something else. Could have been lesser punishment also. But his defense was absolutely not considered. This number one.
And what makes you say so? We'll hear from it. This is your first ground. This is your first ground.
Yes, sir.
That his defense was not taken into consideration.
Yes.
But you have to have evidence. You have to show it from the impugned judgment.
Page 34.
No, you'll show that. And what is the second ground of challenge?
Second ground is that they promoted me. And after they promoted me, and that took on a retrospective effect, I gained some, if I may put it, some immunity type thing. I could not have been terminated on those counts. The law says that if I become a non-commissioned officer, then the punishment so given to me cannot be given. Please the law. So when they promote me with retrospective effect, then they proceed against me by issuing a show cause. Perhaps there also was an error of law. I'll take both the counts on facts and law.
This is by Armed Forces Tribunal.
Yes, Armed Forces Tribunal.
Show us.
The order may not finds at page 57. The Armed Forces Tribunal order.
Page 57.
The order starts. On the operative part of the order.
Let us see first. Give us 2 minutes.
My lordships.
Prior to that posting into the meeting.
But this is the thing you have to find the section of the question of this different देखें इसको क्या फॉल्ट लाइन है वर्ड डालना
What is CPL? It's a short form, kind of an acronym for some post.
Okay.
Well, we don't find any fault line with the original order of discharge.
I pray.
Take your seat and not jump.
Not
on
my
us.
client.
Huh?
Their client.
Whoever he is. When we ask for his
Yes, I got it.
assistance, he will come forward. Shouldn't just jump up. आपसे जब पूछेंगे तब बोलिएगा. Yes. You cannot find it. Correct. If you have to say anything, then tell us.
I understand. Would invite my lord's attention to 2 to 3 things. The first one is that I was show caused after my promotion was given.
You're not promoted. It was withheld because of your being a drunkard.
True.
That's how the tribunal has dealt with it in para 14 of its judgment.
Correct. This was
Mr. Medi, we get distracted by this. You take instructions beforehand.
Sorry, ma'am.
If not, we adjourn the matter.
No, my lord, I'm not adjourning.
Rare that don't you trust your own junior?
My lord, actually, I don't know legs in court number 3, my lord.
You have to trust your own junior and not ask your client all the time. Only when we ask you to consult him, it's not the, this is not the way in which, and I think the gentleman should be asked to go and take his seat in the back. Unless we call for it. Advocates are sitting at the back, he's sitting in front. We have not called him, have we?
No, no, my lord.
Rank he has. किस rank के officer हैं? इधर आए. Again, I'm telling you, this is an act of indiscipline. आपको बुलाया हमने. आपको इस proceeding के लिए बुलाया है हमने. Open court है, कोई भी आकर देख सकता है. आप आगे सीट क्यों ले लिया है? कौन किस रैंक के ऑफिसर हैं आप?
Sorry, sir.
नहीं, किस रैंक के ऑफिसर हैं? मैं कुछ कर नहीं रहा. अगर मुझे एंगर में मैं रहता तो आपको बाहर निकाल देता, लेकिन आप ये बताएं कि आप किस रैंक के ऑफिसर हैं?
जूनियर वारंट ऑफिसर.
बैठिए ना, जब जरूरत होगी तो बुलाएंगे. हर 2 मिनट पर आप उठ रहे हैं. आपके यहाँ एडवोकेट्स पीछे बैठे हुए हैं, आप एकदम आगे में, as if you will be controlling the proceedings of this court. Yes.
My lord, when the show cause was issued, I replied to that. But the order of discharge, if lordship finds it page 33.
That has been quoted in the order.
No, page 33, correct.
No, please, Mr.
Page 33. I'm trying to somehow get a lesser order punishment for my client. I'm trying. I'm persuading on that point. Page 34. Page 34. It starts at 33, the discharge order. Page 34, the last part, paragraph 7, if I may read, And whereas I have examined the entire materials on record in the light of relevant provisions of AF law
Force,
it is-
the Air Force law.
Revealed that the airman satisfied the criteria of a habitual offender for having incurred total count of punishments, entries mainly for intoxication. The offences committed to him are deliberate and no defense whatsoever has been taken by him for exoneration in reply to his SCN.
So therefore, no plausible defense taken. This is missing.
We had taken a pragmatic stand, maybe not acceptable stand. What is my stand, if I may at least convey to
Please.
Lordship? Stoko's reply, page 19, it starts up to 28.
Difficult to keep him in service.
No,
The
he's
explanation which he has given, which
he's
is
a very
apparent
fine
from
person.
him,
They accept him to
which is
define
apparent
otherwise.
from this place, from the impugned tribunal's order, is that he says that he was empty stomach and he had taken liquor, which hit him hard.
It might happen in a given day. I feel
What
that-
is this explanation?
I do not know. It might not be acceptable, but in the circles where the clinical
It's
cases-
absolutely ludicrous.
maybe
Not only acceptable, ludicrous.
he said so.
He said so.
He said so.
Therefore, in this explanation, gives us an impression that while he was giving this explanation, he was drunk. We don't want to say anything. We don't want to say anything behind the back of the person.
I understand.
We are not
I
character
understand.
assassinating
I understand.
anybody. But then we do not find it to be a case where we'll take a different view. It's difficult. Air Force. And he was found drunk in the quick reaction team when he was asked.
He gives a very detailed explanation, although very not so happily worded or polishedly touched. But he says, back-to-back duties, I was empty. And
So that has not been accepted. Tell me,
No, that was not even touched, I said.
how do we justify asking the Air Force to reinstate him in
Page
service?
113 of their affidavit. That is my sheet anchor
Page 113.
of their affidavit.
What you are taking Mr. Mehdi by ambush.
That's what they say. And I
Where
will
is
accept it.
113?
113 of their affidavit.
113 of the brief.
So their affidavit, which they in running that. Yes, sir. 113. May I read the last
As
part?
typed copy. Yes, section 7
Yes.
is written on the top. What is it?
What the commandant says, he says the last part.
Hmm.
Character and general behavior during service good. Trade proficiency and general ability exceptional.
Yeah, go, sir.
No. What I'm trying to say is that
Where is
I'm
this?
good at work, These
These are
I'm saying he's
these
good
are
at work.
no application of mind. He has just written
No,
it.
he's good. He's good at work. Only the punishment could have been less.
तो आपको discharge किया है. You have not been dismissed.
If there could have been something less on job, he tried very hard.
Quantum of punishment, do we have the wherewithals to decide? You know the law. I mean, not you are arguing, but
No, I agree with your lordship.
five entries, 5 drunk entries, punished,
So that's why I started.
and therefore the promotion was withheld. Nobody was against him. There is no bias here.
There's no bias.
There is no bias
No
here.
bias.
He was given time. Only when he
No bias.
qualified to be called a habitual offender
Yes.
was the proceeding initiated. There was no
The
specific
only
complaint.
brain older that may not, if he could be somehow retained with same, because he was exceptional. They
Tell
say.
me whether Ranjit Thakur will apply here for,
I have
for
forgotten that.
reduction of sentence. If you can tell me, we will consider it again. Whether Goyam and Ranjit Thakur can be applied here.
Well,
It was one of the first cases with respect to quantum of punishment.
That I would see. I would certainly.
This is not shocking to the
No.
conscience of the judge. Now, I'm for Air Force discharge. They have been kind to you. They have been kind to you.
That's why he kind
Mr. Mehdi,
Yes, madam.
you succeeded without effort. Huh? Yeah, word also
My
dismissed.
friend tried, madam, in period second.
Dismissed.
Item 39 and 40.
Yes, Mr. Indranil, there was a mention yesterday that you are not well.
I was a bit, today I had to come because my young friend insisted that there is some urgency in the matter. There are 2 repetitions, madam. The first one before your lordship, there's a challenge to service rule. Very interesting. Before your lordships even open the.
So but then you must state the basic facts so that we'll.
That's what this pertains to.
So
The-
first writ petition is for what?
The first in the list, that is 926. There's a challenge to the Assam Local Funds Audit Service Rules.
Assam?
Local Funds Audit Service Rules.
Local funds. Local funds audit service. Yes. Which section?
It is rule 20, sub rule 3.
Rule
Rule
20,
20.
sub rule 3, 23.
20.
Now, can you just take us to that rule where if you have quoted it or the rules otherwise?
The rules are but annexed. If your lordship will kindly turn to page 49.
Page?
Page 49. In fact, the main rules start at page 53. Page 49 is a subsequent amendment.
No. Please take us to 23. Which page?
Page 53. If your lordship first turns to page 53.
First 53. Are you 53? Let us see. 53. Yes.
Now, if your lordship kindly turns the page to the next.
This is called, just a minute, we call Assam Local Fund Audit Service Rules. Now, yes, we turn the page.
The rule under challenge, your lordship will find at page 63.
That is what my friend has.
Sub rule 3 of rule 20. The list of departmental candidates.
No, start with 20.
In fact, if I give a background of the scheme of the rules, it perhaps
After
might be.
after we read the rules, give us the background. Appointment.
20. Sub-rule 1, subject to the provisions of sub-rule 2, appointment to the cadre of audit officers shall be made in accordance with the order determined by the commission in the list referred to in sub-rule 3 of rule 17 and in sub-rule 2 of rule 18. Then 2, the inclusion of a candidate's name in the list shall confer no right to appointment unless the appointing authority is satisfied after such inquiry as may be considered necessary that the candidate is suitable for appointment to the service. The appointment shall be further subject to the availability of vacancies. Now, we are concerned with this for sub-rule 3. The list of departmental candidates for promotion of the cadre of audit officer under sub-rule 3 of rule 17 shall remain valid for 12 months from the date of approval of the commission. So, our challenge is that what it has necessitated, it is a clear error in the rules. There are two modes of appointment to the cadre of audit officer. From assistant audit officer is by promotion 75%, and that is through an internal departmental examination. What the rule says, rule 17 says, is that they will hold the departmental examination, and as and when the vacancies arise, they will go on filling up, and that is the only criteria. Now, the remaining 25% is by direct recruitment. That's from an open source. Now, what this rule 23 has done, it has put an embargo of 1 year in the internal departmental examination, which is supposed to be filled up on the basis of vacancy. Whereas, if it is to be read like this, the direct recruitment select list remains valid in perpetuity. So, in a nutshell, that's the case. And we have faced the examination earlier, and that is all along the understanding of the department also. We have faced
you have taken limited competitive examination.
Because we are in-service people. We are assistant audit officers. We have taken the examination, we have passed. There are further provisions in the rule which says that if we pass in a particular paper, we need not appear because we are exempted. Now we have passed in all the papers. So they cannot.
The difficulty, Mr. What you say is not not bereft of logic. But the difficulty is that the in-service jurisprudence, we go by Sankarshan Thakur.
That is true.
The constitution bench judgment.
True.
Now, how do you overcome that?
In this case, when there is.
This is, we can't say hostile discrimination to a class.
No.
Because the moment.
I'm invoking.
Just a minute. The moment there is a classification, then there is no hostile discrimination. Now, these two can't be compared. Apples and oranges. They can't be compared. These are two different groups. Had it not been the case, you would have been justified in making this argument.
I appreciate what is.
I believe constitution bench judgment in Sankarshan Thakur, if I am not.
Sankarshan Thakur, yes. But here, my lord, I would be arguing 2 points. Number one, the Hayden's principle. There is an apparent mischief in the.
No, no, Hayden's rule will not apply. This is not,
I'll try to satisfy
there
you.
is no mischief here.
There is a mischief because the
Had
mischief
there
is.
been mischief, if the principle would have been otherwise, this could have been said Hayden's. The,
I didn't say
the
mischief.
principle is that from the select list,
Yeah.
a person falling in the select list does not have an indefeasible right to be appointed.
True.
If this is the case, then 23 does not fall for being struck down as the mischief rule of interpretation.
But if your lordship has 17 for a moment, that will clarify the position. If your lordship will kindly come to 17.3. In fact, let us read the whole of 17. Starts at page 60. The only difficulty that I see is that my opposite counterpart does not appear to be here.
You are fine?
APSC has no role to play. This is the interpretation. The state is there.
It is no, we will not waste time in hearing the matter.
It is the state which has to answer.
Who appears for the state? Why is he run away?
So far, Mr. P. Nayak has been appearing.
Where is Mr. Nayak? Can anybody go and call him? This is far off place. Had it been in that building?
Yes,
I
sir.
have intimated your lordship too.
You have given him a telephone call.
I've sent him message also, your lordship.
What does he say?
He has not replied as of now. He's
So
somewhere in
we have to give some latitude to the lawyers.
Yes.
Only on the asking of the lawyers that I am sitting here.
It's
We are
just that,
sitting here for 2 days only on the asking of the lawyers.
And this has, for me at least personally, this has nostalgic memories.
Okay, but we'll be reducing it.
My Honorable Justice Chaudhary would know. This has some very interesting history for me in my.
Let him come. Ask him to come. We will resume after lunch. You should hear all your arguments.
And it should not have so happen that at 2 he comes and 6 for an adjournment.
Huh?
It should not so happen that he comes at 2 o'clock and asks for an adjournment.
Can we presume or can we?
That is the difficulty.
Assess that. You complete your argument. We'll hear him. That could be done.
In that case, my lord, I can proceed for the. I should be able to wrap up in 15.
Not do it.
And, just to indicate the scheme of the things. If you,
No, my brother says that you must come at 2. Don't go back.
His lordship is, I think, deliberate.
You must come back at 2. If possible, we'll dictate the judgment here. If not, where is Mr. Nayak? Since 11:50 AM, how big a matter is that? It is what matter? How would that consume so much of time? Huh? Waste of time. Would he be available tomorrow? If you have some urgency, we will hear you tomorrow.
Even if your lordship decides, perhaps the code of conduct is coming anyways, nothing will be done.
No, we are asking you if you think that it is
I
urgent.
may be able to do it tomorrow. It is
Tomorrow?
absolutely up to you, lord.
Tomorrow, how many matters we have fixed? Whichever. He, Mr. आप ऐसा करिए. No, we have no other matter of the list. You argue. They will hear. उसके बाद देखेंगे.
Today?
हाँ?
Yes.
Because we don't want to retire to the chambers.
We are on the rules, your lordship. We'll come back to the rules.
हमारा किसके साथ कब कितने बजे?
मेरा 4 बजे.
तो हम भी 4 बजे लेंगे उसको. फाइल दे देना. Just give me the file. Yes. We were at rule 20 sub clause 3.
I placed rule 20 sub clause, sub rule 3. I wanted to Page the scheme of the rules. for
Page,
the- Page 53 it starts. So Lordship turns to page 53, this is where the rule starts. If your Lordship turns the page, the Lordship will find Rule 3 provides for the constitution of service. There is a relevance to, that's why I'm pointing this out.
Yes, yes.
It comprises of three cadres, assistant director, audit officer, and assistant audit officer. To this, by way of an amendment, at page 49, an additional cadre of deputy director was added, which you'll also will find at page 50.
At page?
The amendment starts at page 49. And this insertion of the new cadre of deputy director, you'll also will find at page 50.
This amendment was carried out when?
This was
1997.
97.
Yes.
Now, the relevance of this is that for the purpose of recruitment to each of these cadre, the rulemaking authority drafted the rules in such a way that each was under a different part. If your lordship comes to page 58, this originally was meant for only the assistant director, but subsequently deputy director was also brought under this. Part 2 consists of deputy director and assistant director. And the scheme will show that this is the normal procedure of promotion that was adopted, which will be Rule 13 indicates this one. All vacancies in the cadre of assistant director of audit shall be filled up by promotion from the cadre of audit officers on the basis of merit with due regard to seniority. So the criteria provided is merit with due regard to seniority. Now Rule 15 will show that it is the normal procedure of promotion, that is, they have a zone of consideration from which they select double the number of vacancies, double the number of officers, which you'll also will find at sub-rule 2, sub-rule 3. And from that, ultimately, appointments are made, and this list would remain valid for a period of 12 months. This is absolutely fine so far as the scheme of the general procedure of promotion is concerned. Now that takes us to part 3, which speaks about recruitment to the cadre of audit office. Rule 70, promotion through departmental examination. Promotion shall be subject to the following reservations. Sub-rule 1, 75% of the vacancies in the year of recruitment in the cadre of audit officer shall be filled by promotion of assistant audit officer who qualify in the departmental examination called the Assam Local Fund Audit Service Promotion Examination. And the only 2 eligibility criteria are sub-rule 2. He should have a qualifying service of 3 years as assistant audit officer, and sub-rule 3 is what is most important. The Assam Local Fund Audit Service Promotion Examination shall be conducted by the Commission in accordance with the rules and syllabus as in Schedule 3. I'll take your lordship to that a little later. And shall be held at such intervals as the appointing authority may, in consultation with the Commission, from time to time determine. A list of candidates who have qualified in the said examination shall be prepared by the Commission in order of merit and forwarded to the appointing authority. Promotion shall be made from the list subject to availability of vacancies. The scheme of the rules is that a person needs to have a qualifying service of 3 years. After that, he faces the departmental examination. And once he qualifies, from that list, as and when the vacancies arise, these vacancies will be filled up. Now that takes us to Rule 18, which provides for 25% by way of direct.
The difficulty, Mr. Indranil, is this. Long before this was recognized in service jurisprudence, that a panel should not have a long shelf life, because it's prejudicial to the other persons who join later.
Here it does not, that situation does not occur for the simple reason. That is why I placed sub-rule 3 of Rule 17. The whole idea is that this is a purely internal departmental examination. Only criteria is twofold. First is that you have to have a qualifying service of 3 years. Once you have completed 3 years, once you have cleared the examination, you are bound to be promoted. Because, just to clarify.
Therefore, I mean, the entire scheme, this follows the scheme. Now, if it were like this, if the scheme were like this, that anybody who qualifies 3 years and departmental examination, till the time the list exhausts, No further limited
That is
examination.
how it has been all along understood. I'll
I
place
don't
those
think-
facts also.
I don't think
The
so.
reason is this.
That is, then it will be very, very prejudicial to people who come later than you. Because suppose Mr. Y, Mr. Z, they do not qualify for the reason that they don't have the experience of 2 years, 3 years.
Yeah.
Now later, after 2 years, they qualify. After 2 years, they qualify. So in that case,
That will be because in any case, it has to be.
because
not
it is all vacancy based, no? The promotion is vacancy based. And if you keep that list which has been prepared for perennial times, for for any number of years, I think it will be very prejudicial to others. You are the only one who is benefited. Fortunately for you, see, you cannot decide the contents of law or the rules merely by the fact that it has functioned well. Up till now, it was all up to date. Vacancy, list, all promoted. Now think of a situation.
That is what, those are also instances we have placed on record. I will place that. The other reason is this. The whole scheme of the rules has to be understood together.
Everywhere, you take any departmental rules, they provide for this list and which has a shelf life. 1 year, 2 years.
That is what pointing out. That's the normal procedure because it has to be, the vacancies have to be assessed every year. 2000, 2001, 2002. And accordingly, the scheme of the rules itself says that 4 times a number.
No, so therefore, any vacancy, any examination, calendar wise, year wise. Otherwise, you just imagine a situation where junior persons will not have any opening whatsoever.
It runs, in my humble understanding, it also runs counter. Like for example, if today I'm asked to appear in an examination at this stage of my career, and a young boy who has passed only.
How does it matter?
He will definitely score better marks than me.
Age that cannot be given a premium. Now that is difficult.
The other reason I was pointing this out to your lordship.
Suppose there are 50 such promotees who find their name in the select list. The vacancy occurs over a period of 5 years. Then you are the only person, that list is would contain the names of persons who shall be considered for another 5 years. So that's not.
In that case, may I take your lordship back to? If your lordship kindly compares Rule 15 with Rule 7.
We know it will have a lot of seniority issues, fixation of seniority and many things.
No, because the seniority will be in terms
Because
of merit.
if it lapses after 1 year, the select list has no force after 1 year, does it prevent you from appearing in another departmental examination?
The rule says.
No.
Rule says.
Where?
Yes, sir.
Once you have appeared, not appointed.
No.
Once you have appeared, not appointed, you're gone.
No, what it says, the rule says otherwise.
That's a funny.
What the rule says, once you have passed, you need not appear.
क्वालिफिकेशन होगा 3 years रहेगी ओके नेक्स्ट टाइम
और ऐड करेंगे तो फिर seniority से होगा, then something has to be added. Nothing is, you need not appear again, but then it has to be read harmoniously, no?
Exactly.
Because if it is only for 1 year, so therefore it would mean that within a year he need not pass. Or else how do we allow both the provisions to exist side by side harmoniously?
Logic is very simple.
Logic is what we are telling.
Logic is very simple. The logic is the eligibility is just passing of the exam. There is no further criteria. Unlike
बड़ा मुश्किल है. Civil service का list निकलता है. The list is too big. If it doesn't expire next year, then all these persons, every time, these people only would be the candidates who will be accommodated. I don't think there is. You will find thousands of parallels of this provision in all service juris, in all, departmental rules. I have not found anything different unless you can show. And recently we have decided a matter in division bench that it depends. It's vacancy based, but then it cannot be perennial.
the logic is very simple. If you want to compare.
Mr. Nayak, were you there in that judgment where were you appearing for any one of the parties where we decided this? I mean, we did not raise any new question we did not settle any new question. It was all decided from before. We only.
In fact, Lordship, I am holding at least 3 judgments, Lordship, wherein it has been held.
No, but we decided sitting in this constitution.
Yes.
You have that.
In the PW matter, I think, Lord.
That
Yes, I was
Mr.
there.
Mr. Kumar was also there, I think.
Yes.
Where is it? Mr. Kumar was there.
Senior Advocate Ken Chaudhary was
Yes,
there.
yes.
We have
Vishwajit Das.
decided the constitutionality of it. Have we delivered the judgment?
Yes, yes.
Can you give us
Vishwajit Das.
some idea when it was, some
Lord,
idea?
I
when
know
it
the
was-
name, Lord, Vishwajit Das. Thank you. Wonderful.
One second, Mr. Indranil, specific this issue, we have said that it has to be harmoniously construed. There also the same issue. Somewhat similar.
Similar, not select list, but ER wise.
Here the-
This harmonious construction is one of my submissions as well. That is why I wanted to place a comparison
To
of
quote
Rule
my-
17.
1 year validity of the selected 1 year.
See Rule 15 formula.
No, but that argument will not attract our attention for the reason that these are two different classes. Classification, Article 14, different source.
Absolutely. Sources are different, cadres are also different. What I wanted to point out from this, from the reading of both these rules is,
Look at
yes,
this. There are three different points. The source is different.
sources are
The,
different, cadres
the,
are also different.
the bulk is different.
Yes.
Here it is 75%, there it is 25%.
So I'm not comparing with the direct, I'm comparing with the
With the
other
15 and
sections
16,
for promotion.
promotion and 17.
For assistant director and director. Here, this is the normal rule of principles of promotion that has been incorporated under Rule 15. So, please Rule 15 for a moment. Page 58. There is a
उसको एक ही साल के लिए qualified होना है. Because every year the limited examination has to be held. Unless you read it this way, then once he passes and he can stake his claim for promotion, then this entire purpose is defeated. No. Who will come? Then how the seniority will be governed? It amounts to, bringing the coal back to the Newcastle. The same thing, the stagnation continues.
Shall remain 1 year.
I will address what has fallen from your lordship, I'll address that also. But what I wanted to indicate, fundamental difference. If your lordship peruses Rule 15, the requirement is that the selection will be held every year. Now, Rule 15 at page 58.
It goes against him.
Before the end of each year, the appointing authorities shall make an assessment of the likely number of vacancies to be filled up by promotion in the next year. So in this context, if they say that the select list will be valid for 12 months, it is understandable. Here, in Rule 17, what is the provision? The lordship will kindly see. It is not held every year. Rule 17(3), the Assam local funds so service examination shall be conducted by the commission in accordance with the rules and syllabus as in Schedule 3 and shall be held at such intervals as the appointing authority may in consultation with the commission from time to time determine. So what they do is, they hold it once every 5 years, 6 years. Just to give you all an idea.
1 second. Get one more copy.
It is stay away. Right, they said to stay away. Not to stay away. নতুন to.
This was with respect to senior.
নতুন appointment of 25.
Between promoting and recruits.
Again, the same principle would apply, especially in direct recruit class 2 engineering officers association versus the state of Maharashtra and others.
Direct recruits here. Certainly.
No, I'm talking about, I'm talking about the case of Supreme Court. Direct recruit class 2 engineering officers association versus state of Maharashtra and others decided way back in 1990. Now, this provides a protective measure for maintaining promotional avenue equilibrium.
Yes.
So you are suggesting something otherwise.
What
And such balancing is a matter of public policy. This is what we have held.
Absolutely.
A rule can be struck down or read down only if it is manifestly arbitrary and is violative of the constitutional provision. And if there is a classification bearing nexus sought to be achieved between direct recruits and promoters, of course, the context was different. But the principle is the same, that this
Ultimately, my lord,
lapsing,
your lordship interfere.
directing of lapsing of a select list is necessary to maintain the equilibrium. Otherwise, what would others do?
That question would arise, in my humble understanding. In a normal promotional process that is undertaken, as in Rule 15, for the higher cut of the assistant director and director, because there the exercise is undertaken every year. Before the end of every year, the appointing authority makes an assessment of the likely number of vacancies. Based on that, there is a zone of 4 times that is sent to the commission. The commission undertakes a selection, makes a select list which is double the number of vacancies, sends it back to the appointing authority, and the appointing authority makes the appointment on the basis of the criteria breakdown, that is merit with due regard to seniority. Here this is not the case. The case is
vacancies are there, then they will have. So like some see again. The interval word is no.
ये तो बड़ा मुश्किल है ना, ये तो हम किसी भी तरीके से if you approach it from any angle, it will be marring the prospects. It would mar, I mean, MARR, marring the prospects of unions. There will be no promotional avenue for others. You can't read it like this.
Suppose because it will be held in interval, meaning there are vacancies are there.
It's vacancy based.
Just like something.
So इतना ही कर सकते हैं कि vacancy based promotion. Therefore, in one calendar year, if the list survives for one calendar year, that's all. Next vacancy which is advertised, not advertised, notified, and examination held, you also can appear. And any provision which says that you need not pass, it has to be circumscribed by the condition that if the vacancy arises in the same year and no fresh notification has been made, you need not pass.
For that year.
How else do I justify and how to strike this down?
That will be my endeavor to try and satisfy your lordship. Just to, the reason why.
This is Mr. Chaudhary, it is an uphill task for you. We appreciate.
Yes.
It is a difficult task for you. We appreciate.
There is nothing less than uphill that comes to me. If your lordship just makes a note of.
I am sure you are not suggesting that we make it uphill for anyone.
It is always a learning experience. I mean, addressing your lordship and trying to satisfy your lordship otherwise, that is what is the beauty of this profession.
Yes.
But just to indicate the relevance of that holding the examination every year, how the authorities have understood all along is, the rules came into force way back in the original rules came in 1995. After that, they have held only 3 exams. One was in 1999. Thereafter in 2004, and thereafter once I don't have the exact year. So how they have understood is, and there is a logic behind it. The logic is this, Lord, if your lordship kindly.
That's a strong argument.
Yes.
That's a strong argument, but it will not be ipse dixit. That's a strong
I
argument.
will try and supplement with a few judgments. Now, what the logic behind this is, as I was pointing out to your lordship, this is provided at page 69 of the rules. If your lordship comes to the rules, the syllabus provided, schedule 3.
No, उससे कहाँ जाएंगे?
No, what that says.
I think let us not
I'm not-
move astray.
No, I wanted to point out that the syllabus itself says that any paper that you have passed, even if you subsequently appear, you need not appear again. So if a person passes, going by that logic, if a person passes all the papers, so he need not appear. And it goes very well with 17.3, spirit of 17.3, for the simple reason. That is how they have understood. What they have done is, if your lordship comes to 69,
And after 95, there have been 3 such examinations.
only 3. And that is how they have dealt with. They allow vacancies to accumulate. And then they hold the exam. And they exhaust
That was a faulty implementation. Now come to this 15.3. It has to be notified. 75% of the vacancies, 17, we are reading 17 at page 60.
Yes.
75% of the vacancies in year of recruitment in the cadre shall be filled by promotion in a department called as so and so.
This is for the purpose of identifying the 25% direct recruits. If your lordship see.
No,
Rule
number
18.
three. The such shall be held, the examination shall be held at such intervals as the appointing authority may in consultation with the commission determine.
Leaves it open.
In as such interval.
Do away with that.
And
prohibitions and clause
the
three.
other absurdity that happens is, if your lordship see, rule 18 is a direct recruitment. That is where Supreme Court has time and again said that in the meantime.
The
if your-
maximum you can suggest that till the time another vacancy is notified, then the list should survive. Maximum you can say that.
What?
That is only a practical reading of section 20 subclause 3. Suppose
That is what we have done. That is why we need to file the other.
that would be
admission.
then
It's
others
Not exhaustion.
then others would come, all those who qualify 3 years, who pass 3 years, who serve for 3 years, they qualify. Then they would clamor for the examination to be held immediately.
But there is no right that is conferred under the rules.
And-
And holding of examinations every year.
There is no right for anything. Only right is to be considered. Same handicap is with you. You may have fallen in the list, but there is no indefeasible right.
Your lordship will-
Question is striking down a provision of a statute
I'm not
requires
striking. I'm asking for a reading.
a reading also is equally important.
Logic is very simple. If it's to be understood as it is, Rule 23, what it does is another further dangerous thing. The direct recruitment list does not have a shelf life.
That we already said, no, you can't compare oranges with apples.
No.
Both fruits being good for your health, but these are two different genus.
But-
And therefore Article
You can
14
certainly-
Article 14 comes into play.
Likewise, Article 14 will also come. Now, why I am laying emphasis on that?
Article 14 and Article 16 comes into.
Why I am laying emphasis on that is it creates a further absurdity to the extent that a direct recruits list will remain valid in perpetuity.
Mr. Naik, just at this point of time,
And they have
we are not asking you to answer theoretically. Is it a fact that from 1995, you have only held 3 examinations and therefore 3 lists?
Probably it is correct, because in last
Then
advertisement,
how do you justify this 1-year cap?
but that is the general provision, Lordship. Once select list is declared, whatever vacancy arises in that period,
No,
Lordship, we keep
It's
giving
it's
a.
very specific that it lapses after 1 year.
I do not consider it as a lapses, Lordship, because rule provides. And if Lordship reads Rule 17, Lordship, that 1 year criteria, Lordship. 15, general procedure of promotion. So promotions are for different posts.
But this
So it is not particularly to the post of audit officer.
So
It is only a
we
general
are
procedure.
talking about a list of particular honor of officers which lapses after 1 year.
Yes.
Could you give it a life? Could you flag it again
Lordship,
till the time you
Lordship,
notify
Lordship,
fresh
This
vacancies?
matter involved other aspects also.
No. And
Lordship,
this other aspects we will give you.
when the matter is sub judice, department took a decision that your list got expired, so we are not going to give you appointment. Accordingly, new advertisement was issued. Advertisement,
Agreed. That is plain reading of the rules.
It is the
Where we are,
Lordship,
we are
that,
with you.
that
Mr.
decision of
Naik,
the government was never challenged.
Just a minute.
Not a single
Let it
representation
not be
was.
challenged. आपसे पूछ रहे हैं कि आप कहाँ चले जा रहे हैं. We are with you, Mr. Naik. Therefore, don't think that every observation of ours is to be, repudiated or challenged.
No,
नहीं, आप-
no.
we are with you because of the service jurisprudence, not because we have any special affinity with you, but because this is the principle which is usually in vogue in all such departmental examinations. But considering this aspect of the matter, now, is there a situation when when was the first limited examination held after 95?
95 and 99. Thereafter, in between one more, no, the first was
18
held
is-
in 99.
99,
Second was held in 2004.
2004?
And I am told, Palak, there was one more held where they could not even find any candidates.
No, ठीक है. So 1999, when a list was made from 1999, promotions were made in the year 1999 and 2000.
Not there.
Later also,
Yeah.
it continued.
That is why in fact, I have placed off material on record. It will also comes to the,
But that would, they have faulted.
no, that is how.
Then they have not applied the rules properly.
In fact, this very selected, the appointment, the advertisement was, The advertisement was on
That
25
has not-
2018. They made appointments to 27 within the 1 month. But additional 5 candidates were appointed in September 2021.
But it was only in between the two examinations held. In between the two examinations, suppose a list was prepared in 1999.
No. In this, I am talking about this.
You tell us this about 1999.
99.
So lists of say 25 persons were appointed.
Yes.
We are just giving what is that?
Hypothetical.
Hypothetical figures.
Yes.
25 persons were there in the select list. Now, out of them, 20 were appointed in 1999 or 2000, whichever, I mean, one calendar year. And then any vacancy arising in 2021, because no examination was held, this may have survived for their consideration. But can that be the interpretation? Can that be? This is what we are asking. We are treating it judicially. They may have been inactive. They may not have followed their own rules.
In fact, that is the reason we have had to put this rule to sub-rule 3 of Rule 20 to question. The not only has this, the spirit of the rules indicate that since it is the internal departmental examination, once you have the 3 years and once you qualify, you are entitled to be promoted. That is a right that flows from 17(3). And
From the
that is
those posts already on the date of examination is notify किया.
No, बाद में notify किया. वो तो as and when it comes. But since they did not,
Exam कब होगा?
since they did not undertake that exercise of holding the examination, they kept it alive. This is the past experience, what Mr. Chaudhary says. But this is bad handling of the situation. That's against the rules.
two things, if I may again take your lordship back to Rule 17(3). Two things are indicative of the intention that I am trying to advance before you.
Yes,
Not only is that
Mr. Chaudhary, we are not cutting you short. Intention देके क्या करेंगे? If the words of the statute are clear, we don't go behind it.
It is clear.
If it is slightly ambiguous, then we look at the intention, we look at the notes, we look at the heading, we look at the debates. But if the wordings are absolutely correct, it lapses in 1 year. That it was not followed in yesteryears, can that be a ground to ask the court to strike it down or read it down?
Absolutely not.
Read it down.
Absolutely not. What I am on is, if your lordship will come to that appeal rule, sub-rule 3 of Rule 2. My only argument is, I can supplement it with other submissions. My submission, fundamental submission before your lordship is, if your lordship will come back to page 63 for me, the appeal rule. The list of departmental candidates for promotion of the cadre of audit officer under sub-rule 3 of Rule 17 shall remain valid for 12 months from the date of approval of the committee. My submission before your lordship is, this is perhaps a very fundamental error. It should have been 18(2) instead of 73. If we read it as 18(2), all problems are solved. The direct recruitment list remains valid for 1 year. And
You're suggesting something which is beneficial. And we can't substitute our reasoning, no. 17, this is sub-rule 3. एक बार फिर से sub-rule 3 देखिए. The assigned local fund audit service promotion examination shall be conducted by commission in accordance with the syllabus and shall be held at such interval as the appointing authority. Appointing authority वही है state है, in consultation with the commission from time to time, because they have to undertake the examination. A list of candidates who are qualified shall be prepared and it shall be made. Now this यहीं पे
promotion shall be made from the
available list subject to the availability of the vacancies. ये तो उस काल का खत्म हो गया और ये बताता है कि 1 साल में रह जाएगा. How do we read it down? That they have worked it, that they have for all these years worked it out in a different way. It depends on them. If they decide to keep it alive for more than 1 year, don't want to conduct examination, we have no problems. But we can't say that you please do it.
On the face of this rule, if they have understood it all along, and your lordship is aware of that N. Suresnathan's case followed by the cylinder running. If a rule is being if a rule is being understood, interpreted, and applied in a particular manner by the authorities and all through consistent, the rule has to be interpreted as such by the court. That is the principle laid down.
If that is the principle, then what is that judgment? Where Senior Justice Chandrachud had said, what is that? And it was reversed after 70 years. ADM Jabalpur.
There, mother,
Which principle? Which principle?
but this is on a different note.
You can say that's a constitutional principle. This is service. Why do we say that the law is dynamic?
That's true. That's how it keeps evolving all the time, especially under while
The law evolves. The law evolves. Otherwise, there would be nothing. It will be all static.
Back, Mark, every time I'm addressing your lordship from the writ side under 226, it always takes me back to the famous Gauhati case, paragraph 4, where it says that this is the reason why Article 226 was inserted. Because it's an extraordinary jurisdiction. It requires a very broad approach. But these are the complex situations that keep arising in our country. I mean, ultimately, your lordships have to settle. The last sentence of sub-rule 3 of Rule 70, that is also indicative of. First, it says in the middle of that rule, it says that it will be determined from time to time at such intervals to be determined. And the last sentence says that promotion shall be made from the list subject to availability of vacancies. So I have, in my humble understanding, one of the interpretations would be
उसका shelf life हो गया बाटा की चप्पल टाइम.
They will take a pragmatic approach. They will have a practical approach. Find out how many vacancies are there. Find out how many people are there in the feeder garden. And then they will make an assessment that we will hold the selection. And once these people are clear, as and when the vacancies keep arising, they will keep on filling. And it goes perfectly well with this provision that once a person passes, he need not appeal. This whole scheme read together, and further, the fact that Rule 18 does not provide for a shelf life.
Even with respect to this, no? Even 15, general procedure for promotion. There also they specify, the list finally approved by the commission shall remain valid for 12 calendar months.
Because that is the general procedure for promotion.
Promotion shall be made in accordance with the list finally approved. And maximum extension also is permissible under special circumstance for 3 months.
That extension is not there.
Intention here is, but they have applied different intention. They intended differently, worked out differently, but the intention is clear from a composite reading.
In fact, it is in this context, the facts also would be relevant.
Where is the provision, Mr. Nayak, that if the vacancy is declared and you hold departmental examination, double the number of vacancy or triple the number of vacancy?
That is not there, Lordship.
There is no
Lordship,
such.
criteria is if you have completed 3 years, you are eligible to appear in the examination. And if you score a particular marks or above, you are selected candidates, Lordship. In this case, Lordship, 18 advertisement was issued.
We don't talk.
The fact is very relevant, Lordship. That is why I am trying to. Lordship, at that point of time when the advertisement was issued, notifying the examination, 32 vacancies were there. List was published in 2019. At that point of time, on the date of publishing the result, 54 vacancies were there. In the list, there were 59 candidates. Some unsuccessful candidates, Lordship, filed a writ petition. Court stayed the select list, saying that give appointment to 32, remaining will not be given appointment. That was the initial situation. Our intention was that as the list contains 59 names, 54 vacancies were available, we are going to give.
But you have not notified those vacancies for examination.
Lordship, there is no question of notification. This is only the promotional examination is required to be notified. This is a promotional examination. Whoever is eligible.
That possible.
No, this is not direct recruitment.
Then what number do you select in the select list? What number do you put in the select list?
Look, whoever scores that particular marks has been notified.
And you keep it pending only for, you keep it alive only for 1 year.
1 year. That is the rule, Lordship.
And when it happened that more number of vacancies arose during that calendar year,
Yes.
the High Court restrained you from filling up those vacancies.
No, that is not there.
Then you said so.
No, in this list, Lordship, 59 names were there. 54 posts were there. So we are in a position to give promotion.
You were, but you said that the court said that no, only 32.
Court said because they are
We are asking,
no,
so
their contention
said for the reason that you, I mean, the list, the vacancy that you, do you notify the vacancy?
Lordship, that is the understanding, Lordship. In my 5 affidavit, Lordship, we have taken a clear stand. Lordship, as this is a promotional examination, we are not required to notify the vacancies. We should not also. But in that advertisement, the vacancies were, indicated. We only required to indicate that such and such examination is going to be held on such and such day. What is the number of vacancies that we are not required to, indicate or
If that is there, then perhaps.
this is not
Mr.
direct recruitment.
Then if that be your intention, then Mr. Indranil is all right. Therefore, then you're not following that 1 year rule. For following 1 year rule, you have to specify.
Lordship, that is what I am submitting, Lordship, repeatedly. If you are aggrieved because of the decision of the department that your select list has been not given effect as it has already crossed past 1 year period, you never represented. You never represented for extension of the validity of the list. You never approached this honorable court during when the matter was sub judice, my select list has been not given effect or it has been decided not to give effect. You are not aggrieved. It is your fault, Lordship. Just because, what is the fault of the rule, Lordship, for that, Lordship? Rule is there.
The answer is very simple. From the same select, the select list was notified on 7/11/2019. After giving 27-28 appointments, they gave another batch of appointments in 2021.
So
we
he had
were under
reasons to
bona fide
be agreed.
that you are, since you have done it all along, that this is how you have understood the rules. After 2 long years, they gave appointment, and we were under the belief that we wouldn't know how many vacancies are there, what is there. So we were under a bona fide belief that our turn will also come. All of a sudden, out of the blue, they say.
No, but why should it have come? Others also would have crossed 3 years threshold and would be desirous of writing the examination.
New eligible candidates, Lordship.
Possible, but the rule says that it will be done as determined from at such interval.
Therefore, all the more reason why we are insisting that this 20 subclause 3 is operational as and when it is notified. He has taken a stand. I don't know why the state has taken that stand that we don't need to notify. We just notify the examination date.
So the vacancy, it is not a vacancy.
That is not required, Lordship, because
It is vacancy based. No?
It is they have to conduct the examination and after that fill up as and when vacancies arrive.
Suppose the rule would have obligated them to hold examination every year. Situation would have been different. They don't say that.
And then it would automatically correlate to the number of.
It has to be vacancy based. No, otherwise, what is the timing? Have they said that every year as a routine in March or April, they will hold the examination? No. Can it be so fluid that it could be used in any manner whatsoever?
It's not used in any manner. What I'm trying to say is, if your lordship reads the whole provisions of Rule 3 of Rule 70 in totality, what it is indicative of is the rulemaking authority gave this power, conferred this power on the appointing authority, that they, in consultation with the commission, will determine the interval of the examiner. Here, in this particular case, since the notification of the rules, they have held only 3 examinations since 1995. So, which means
that is an argument which we have taken into account. It's a very strong argument, but that is not an argument which you can advance on demurrer.
So,
You can't advance this argument on demerit.
not in isolation, but everything taken together.
But you understand what I say when you can't advance it? That they have no case, allow my appeal, allow my prayer.
No, I am not.
You can't do this, no?
I-
Because there is black and white statutory provision.
I am on, just to summarize my submission, what the limbs of my, first limb of my submission is reading 17(3), then 18, and then sub-rule 3 of Rule 20. There is an apparent mischief in the rule. The mischief is, I'll try and summarize the mischief of it.
Don't import that principle here. You can say that it is unworkable. It is
That my second-
unworkable. We will not, that ship's case, that mischief which was conceived of in Hayden's case is different. Now, you say that it is unworkable.
I will place my judgment on that also. What has happened is, this has left a internal departmental examination with limitation of 1 year, whereas it leaves the direct recruitment open. So in my Hindu
But again, this argument you please withdraw, we reject it totally.
submission-
These are two different things. Apples and oranges, again, we come back to you with this example.
On occasions when the orange is good but the apple is rotten, I guess perhaps giving the other limb of my argument is, it creates such an absurdity. Whereas again, the rule itself says that once a person passes, he need not qualify.
So this could be read down. This would be applicable for a year. Suppose they make another list. They have to consider you. Or they hold an examination, you need not pass, that list will continue. But 1 year. Otherwise, bypassing the rule is their domain.
So if they bypass, also someone might come and say.
Can we talk about the applicability of a rule in a consuetudinal manner? This is no custom or usage.
I'm not.
It is governed. We are only testing it. I'm not rejecting your argument. We are providing our own logic to question the argument. I mean, unless we do that, whatever you say, I accept. Whatever he says, I accept. That's not. We are only offering our contentions. It's a matter of debate.
Yes, sir.
We don't consider it to be a one-way traffic. Therefore, we are suggesting to you that that they have not been able to do it. Do we say that this practice and usage makes it like we have that case in that Industrial Disputes Act, old time case, that at the time of filing your written statement, you have to say that you will like witnesses to be examined. If you don't say it at that point of time, then the opportunity is lost. Later in the Constitution Bench judgment, they said that this has worked well, so we will not change it. Now, something like that can be done only under 142. Something like that can be done only under 142. We can strike it down if it is unreasonable, manifestly arbitrary, or we can read it down if it has to be made workable. But only on the garb, we are testing ourselves. We are testing the remits of our power under 226. That's how we are dealing with it. Now, let us see this. That it has not been done. Can we say that from 1995 till 2026, this has assumed the character of the rule, and therefore no deviation is required now when it has worked properly? Can we say this for this kind of a service rule, which is there in black and white? And it is not a novel feature in your rules. This rule is available in, you can check up all states, all service rules. If there is a provision for, either they say that there will be no concept of wait list, no select list. There will be a cutoff. All those who cross that cutoff marks, and that cutoff is also variable depending upon the performance in that examination and the number of vacancies. This is how it becomes very, very, cut and dry, where nobody will have any objection. 50 seats are there in the promotional quota. You hold an examination notifying that there are 50 seats, and then inter C marks a cutoff threshold is seen, that threshold is always decided by seeing the entire result, and that is where the commissions, any body undertaking the examination, that decides that with this cutoff we will have all these. 1 or 2 or 3 or 5 is there in case of non-joining. Somebody from below the, no, there are rules which says that if you don't cross the cutoff marks, even if the vacancy is left, that cannot be relaxed. But then many a times it happens when there is no strict barring or diaphragm kind of an objection. Those who do not join leave a seat vacant. People from beneath the list, they migrate up. This is how system works. But here the rules are faulty, but the rules have to be understood in the terms of what has been laid down clearly in black and white, which is not capable of suggesting any ambiguity in the rule. That they have not done is their fault.
So that is the ambiguity in the rules that I am trying to satisfy you. It would not have been unambiguous, had it been, my lord, that they also had a similar provision in so far as the direct recruitment is concerned. That is why I say that it is a very fundamental error that has crept in, perhaps even inadvertently, for the simple reason we could lay our hands on the communication of the department, which say that we need to amend this. And that has also been placed on record. The logic is very simple.
ये कर सकते हैं आप इसको वैकेंसी बेस बनाया और स्पेसिफाई नहीं किया कि साल में एक ही बार होगा, आप 4 साल में करते हैं, you have been doing it, so you are not following it, so it is a dead letter here. But then can we do it sitting in this jurisdiction? Question is कि ये तो सर्विस रूल का एक बेसिक टेनेट है ना, there is a basic tenet that everybody should get an opportunity. We are not interested in either Mr. Indranil or Mr. Nayak. Question is that persons who enter the service, they cross the threshold, they cross the Rubicon, so to say. Everybody should get there should be promotional avenue equilibrium. What you are suggesting, Mr. Indranil, is something which gives you primacy, because once you have passed, you were there in the select list, for some reason or the other you were not appointed, your candidature will continue.
Because once they started.
अच्छा, आप शंकरशन ठाकुर पढ़ाइए तो let's see.
Slightly
No, principles are same.
It is not, you cannot go beyond the notified basis. This does not talk about.
You have the copy of citation.
It is about the right of appointment up to being selected.
Here also we are questioning it. We are testing your submissions on the basis of the right which you are claiming.
Here, this is a
He's claiming a right. He's claiming a right after completion of 3 years and passing of the examination.
Convention is one of direct recruitment, firstly, and secondly.
वही ना है as a government. If a vacancy exists. This appeal was earlier heard by division bench and was referred to for examining the question whether a candidate whose name appears in the merit list, just read it that way, on the basis of a competitive examination acquires indefeasible right of appointment as a government servant if a vacancy exists. The vacancy keeps coming. The reference was made to the decisions of Subhash Chandra Marwa, Nilima Sangha, and so on and so on. The constitution में यही है ना, BC Ray, KJ Shetty, LM Sharma, MN Venkatachala, and जैसे वर्म. He's right, this is for a different issue.
Mm.
Which other judgment you said that it is?
This Sankarshan Das itself.
Sankarshan is,
Just paragraph
all right.
seven.
Oh, we'll have to apply a lot of inferential logic in applying this.
In paragraph 7, there is one sentence I would like to draw upon. Paragraph 7 at page 51. At the very top, towards the right, your lordship will find a sentence starting unless. Unless the relevant recruitment rules so indicate, the state is under no legal duty to fill up all or any vacancy. So here, even if Sankarshan Das is taken into account, the rule 17(3), read with the schedule to the rule, indicates that I have some right. Once selected, I have some right. So that from Sankar.
We are not even for a moment thinking that you don't deserve. You need to be considered. But question is that if we change the rule, then it will be very prejudicial to persons who later in point of time they cross the threshold.
Your lordships can indicate that it need not necessarily, because all along they have understood it in a particular way, that this rule 23 is not applicable in so far as 17 is concerned. That is how they have all along given appointments beyond the one and beyond the notified vacancies. Just to give you an example,
You have said that.
And
You have said that.
yeah. So on previous occasions, they not only notified the number of vacancies, they made appointments way beyond the notified vacancies and also way beyond this expiry of the 12 months. Here also, in this particular advertisement in question, where we were selected, here also they have made appointments. At least we have materials to show that there were 5 appointments made after about 32 months of the notification of the slip.
Before conducting a new
Conducting came, they wanted to appoint. The unsuccessful candidates, the people who failed, they came and filed a resolution. And this pendency prevented us from being able. Almost 7 years. Otherwise, they were taking up a position that we would like to appoint. And in fact, they say so by way of an affidavit that notifying the vacancies is not necessary. And they have been doing so. It's been making so.
133.
So,
Paragraph 12.
everything taking
Consent
the
since it will be held after notifying,
but-
so it will.
if I had to give it, if I had to interpret it in the manner in which a usage or a custom is, concretized by law,
there was
I think you have a case. But we are only looking at future jurisprudential, contextual reading of the act. That's our difficulty.
While preparing this case, at a certain point of time, I had also thought of arguing the doctrine of decibel. I did not want to stretch it that far. So, in a way, even that.
Service law में dissuitude कहिएगा तो कैसे काम चलेगा?
That is precisely the reason I avoided. Precisely the reason I avoided.
This is one of the most rule-based jurisprudence.
There are occasions like in the Suresh Nathan's case and Sarvendra Tanya case.
You can argue dissuitude. The others will say that look, this concept, the whole what was the fun in enacting the rules in 1995?
They could have done it. If your lordship see what they did, all that was required, rule 15 and what has fallen from your lordship, all they were required to do is modify rule 15, and instead of saying merit with due regard to seniority, they could have simply said departmental authority. That would have solved the whole issue. They would have held the examination every year.
We are absolutely unhappy with the rule in the sense that they should make it. They have to notify the vacancy in the promoted quota and then hold the examination, which I don't think they insist that we don't do it. That's not done. I don't know. I'm surprised. This is how if you make rules and you make it workable, the only God can save. That's not the current, national trend of dealing with servicemen.
और ER-wise भी नहीं है, जब मन करे वो
जब मन करे तो
करेगा, then why 12
जब मन करे तो परीक्षा लेंगे, जब मन करे तो वैकेंसी बताएंगे, and leaving everything in the hands of the appointing authority. This is no way of dealing with employees.
And it will so happen, if we are deprived, we'll be the first lot of employees since 1995.
I have not seen this kind of rule in two jurisdictions that I have served, neither in Bihar nor in Delhi.
It's a very rare provision.
It is no
Lordship-
provision. If
Lordship,
it is
in
not,
fact- in
if
fact,
it is
if
not
Lordship-
very clear, it is not clear.
If Lordship permits me, Lordship,
We will
please.
hear you. We will hear you. We'll hear you, Mr. Nayak. You are one of the most important stakeholders in this case.
In the
We
last-
will hear you.
In the last 31 years, we'll be the only group of employees to not be appointed in spite of having passed it. And they could have very well appointed vacancies. We have in fact placed that also on record. They,
You were showing some judgments.
on, since your document is not really inclined, just give the reference.
No,
On Hager, just to.
Honey, why not? We are not inclined to, we don't sit with a closed mind. जब दिखाइएगा, whenever it appeals to us, we will change the direction of the wind.
This is a famous caravan company.
हाँ तो वही ना है.
I'll just refer to two paragraphs. I mean, how this principle is to be applied. First, paragraph 21. This is 75 to SSC 791. May I take your lordship to para 21?
Internal page of that.
Internal 802.
Yes.
The law is not a brooding omnipotence in the sky, but a pragmatic instrument of state law. It is an operational art controlling economic life, and interpretative effort must be imbued with the statutory purpose. No doubt grammar is a good guide to meaning, but a bad master to dictate. Notwithstanding the traditional view that grammatical construction is the golden rule, Justice Frankfurter used words of practical wisdom when he observed, there is no surer way to misread a document than to read it.
These are of yesteryears.
This perhaps was taking it a little too far, but still.
This was of yesteryears. We can't treat it lightly. These are pearls of wisdom from great people, no doubts about it. But the relevance is gone today. With so many laws that there is a requirement of deleting many laws. We have such rules, no? This was a time when things were very, things were not so clear. There were not so many judgments in the service jurisprudence, and many inferences had to be drawn. This was a situation when law was fluid. Now with the passage of how many years? How many years after the constitution was promulgated? 1950. And today we are in 2026. So makes it 50 plus 76 years. 76 years, I think these principles will not operate.
But this para 21.
There is, I mean,
24.
With great respect to the gentlemen who use these pithy sentences, but are we using this, and would we not falter if we use this line that there is no surer way to misread a document than to read it literally?
I wouldn't stretch it that far, but I would certainly take your lordship to para 24.
Very pithily said, but these are, what is it called? These have been reduced to shibboleths. These pearls of wisdom, they have been reduced to shibboleths. No practical utility today. No practical utility.
On occasions there.
When there is ambiguity, press these principles.
If I may place para 24 also.
Very good read, but no doubts. Very good read.
If the language used in a statute can be construed widely so as to salvage the remedial intent, the court must adopt it. Of course, if the language of the statute does not admit of the construction sought, wishful thinking is no substitute. And then not the court, but the legislature is to blame for enacting a damp squib statute.
But if we take this, then we can't do anything. We can only ask him to reconsider.
So, reading further, it does not end there. In my view, minor definitional disability, divorced from the realities of industrial economy, if stressed as the sole touchstone, is sure to prove disastrous when we handle special types of legislation like the one in this case. I admit that viewed from one standpoint, the logic of Sri Gupta is flawless, but it also makes the law lifeless, since the appellant is thereby enabled neatly to nullify the whole object of Chapter 3, which is to inhibit concentration of economic power. To repeat for emphasis, when two interpretations are feasible, that which advances the remedy and suppresses the evil, as the legislature envisioned, must find favor with the court. Are there two interpretations? That it goes on to deal with the facts of that case. So my emphasis is, here is a situation, it has created a situation of two interpretations. And your lordship will suppress that mischief and advance it. Another judgment on the absurdity of rules, 2011. This is the Narmada Bachao order. 2011 7 SCC 639.
Mr. Chaudhary, since I've used the word absurdity, we say that if we apply this logic, it will be akin to reductio ad absurdum. I'm giving you an example. Road is wet, and therefore the inference that it must have rained. How absurd it is. It could be wet because of other reasons.
Here my endeavor. Here my endeavor.
We are not getting, see, absurdity, the absurdity argument we would have understood. Mischief we would have understood, provided the rules were not so explicit, number one. Number two, this being a service matter, which are just rule-based.
But what?
Where neither consuetudinal principle nor the rules of desuetude would apply. It's just the literal meaning.
But although I use the word absurd, here is a judgment. The reason I want
No, we have nothing against that usage of the word. We are only saying there is a principle in law, and that also principle of interpretation, which gives you this kind of latitude, which is called reductio ad absurdum.
Yes.
That is how, with such absurdity, you deduce a particular proposition.
The reason I wanted to place this judgment is, this is a judgment which dealt with these kinds of ambiguous situations in the provisions.
This was a judgment in the context of 100% acquisition of an undertaking. The conceptual background is different.
But your
कैसे होगा?
large number of judgments.
Suppose पंचायत rules हैं आपकी. There you have other rules of service. Now what is written there, you have to go by the literal rule unless it is capable of being, being interpreted differently. That they have not worked it out in the manner in which they have intendment is clear. There are some missing points which we don't want to legislate. We will say we can. Your argument is not worth rejecting, but your argument is not cannot be a demurrer argument. It is not worth rejecting. We must admit.
This will be, as I said, at the cost of repetition. This will be the first time in the history of the department that we as a class would be left out, in spite of having passed. And
this may be true. This may be a statement which is very, very Assam specific. Everywhere it happens.
Your Lordship,
every year in UPSC, the select list comes, people are appointed, vacancy closes. Now these people appear again. Never.
In open-ended examinations, certainly. Here is a case, it's a departmental exam.
That's right. Departmental examination, which is vacancy based.
No.
Calendar. What? वो कैसे कहेंगे? When the government advertise, the government in consultation with the commission conducts the exam.
Vacancy based, but they are not saying ERO is vacancy. That's why not there.
That's
appointment is vacancy.
ERO is vacancy only say then.
Fill up the gap. Mr. Nayak has taken a stand which is neither here nor there. I mean, his government has taken a stand which is not very intelligible.
In respect of the the regular promotion.
No, we are only thinking of the service as a class.
Yes.
Therefore, this objection.
The
No,
fundamental
otherwise, it makes no sense. No, you make a person eligible after he crosses 3 years tenure and then passes an examination. You hold the examination at your own sweet will because it doesn't, the rules does not provide for a time limit or calendar based or vacancy based. So these are the loopholes which have to be filled in. These have to be plugged. But we can't read down a provision which is very, very clear, like water flowing through the Brahmaputra, that the select list shall be for 12 months. इसको क्या करें?
Just to show how the department has how long understood, just one document if I may place for my satisfaction. If your lordship will kindly come to.
ऐसा है ना कि नब्ज वहां पकड़ाया हुआ है, आप उससे you can't, we are stuck up at that. Unless you make us loosen our grip on that provision 23.
I know.
Difficulty है. We are not in a position to go. हमारा दरवाजा खोलिएगा. If you open the door for me removing that stranglehold of 23, we will proceed. We are thinking. No doubt, we are not closed. Windows are open, but door is closed. Can't jump out.
I cannot wishfully make it go away. That 23 is there as it is. I have to try and overcome that first.
Wait, but that stranglehold we will hear you on some other day. अभी तो एकदम फंस गया है, वो record फंस गया है वहाँ, भाई. Like old gramophone, I am not able to read beyond 26+3. Gone are those days when one line of a song only used to play. Right? Fortunately, it doesn't happen today. Arguments to continue. Give your notes of argument.
Yes.
And not bullet points.
Yes.
Give a narrative one. Let's see. And that's true for you also. You can
In fact,
think
also,
about
I am
meeting the rules.
I am not against this petitioners. My only intention that the rule 23 should not be read down or it should not be interfered with. That is my only intention. Otherwise, Lordship, I am very much sympathetic
You
with them.
you need not suggest that. We ourselves know our remit.
Yes,
Even if you suggest, we will not be able to say that please don't do it. We know our remit.
that is what I feel, Lordship. In
No,
fact, Lordship, this rule has
Unless
always been
it
interpreted.
is required to be read
favorably
down
to them.
literally, we don't. Because rule making power domain is with you.
Yes.
Now we can only say where you have gone wrong. This we can say here, that with this open remit with you, you have worked it out in a most incorrect manner.
Lordship,
Despite being the rule
we
of which
waited-
you are the originator.
in fact, Lordship,
you have not
waited
followed it.
till a certain time, from 2018 till 2024. Next advertisement was only in the year
Naik,
2024.
one argument of Mr. Chaudhary could make him win the case. He says that up from 1995 till 2026, you have only taken 3 examinations. It presupposes that after every examination, there was a gap of several years and you kept that select list active. Live.
That is why, Lordship, I have submitted. Lordship, this rule.
And only after exhausting, you have done held the new examination, which is bad. I don't know why the other persons who crossed the Rubicon, they did not challenge it.
Lordship, because number of officers is very limited, Lordship.
That is
And
the-
that is why I submitted
laws-
this
laws-
rule, Lordship, has
what is-
always interpreted favorably to the officers.
Therefore, we can say that well, this is a peculiar way of drafting service rule, where nothing is clear. You decide that we will hold examination after 3 years or after 1 year.
Because
It is not
audit
based on vacancy, it
officer
is not based on
the-
calendar month.
So far,
These were the principles some 25, 30 years ago, maybe 50 years ago. Now with the service jurisprudence having attained such wide interpretation, you can't make this rule survive. If we go on that line of argument, with the entire rule is faulty.
in fact, in Rule 15.
Cannot be. It has to be either calendar based. Without notifying the vacant position, you will hold the examination. Surprising. You don't do it for your appointment of teachers. You don't notify the
I will try
vacancy.
to satisfy your Lordship. But
what
we
you-
only notify the examination.
Examination.
Do you think it's a correct way?
That is the law, Lordship rule. Lordship will read 17.3.
But that is what I'm saying, that this rule is very faultily made. That
15
question
is-
whether we can enter into that or not.
15 is better, because 15 say year-wise vacancy, then year-wise select list. 17
that
says,
is the general
then when
provision.
ऐसा open area रखा है आप अपने advantage के लिए कि whatever I will decide, I will do.
That is the reason, Lordship, why I am saying, Lordship, this rule has always been interpreted favorably to the officer.
Why don't you accept his case?
There is a limit to everything, Lordship. 2018, 2024. In between, there are many other eligible candidates, Lordship. That is the reason. How long we can wait, Lordship?
You're keeping it reserved for somebody else. Mr. Naik?
Because of courts, first of all, Lordship, stay order by the court, then pendency of the case, Lordship.
This does not present a good
In fact,
scenario.
Lordship, this matter was filed only in the year 2025.
No matter whatever you say, this does not present a good scenario.
Expectation
Where the rules are vague, it is capable of being misread, misutilized and misused. And that cannot be done in the present day when there is so much of transparency everywhere. Should not be done. आप चला रहे हैं, इतने दिनों से आपने किया है, आप अपनी इंटेंशन को कभी जाहिर कर देते हैं, कभी कहते हैं कि मेरा इंटेंशन नहीं है, तो डिपेंडिंग इतना एडहॉक रखिएगा तो फिर बहुत मुश्किल है. We will decide. We have not opened our mind. We have not closed his argument. And we will strike it. We might say that this requires overhaul immediately. Otherwise, it is fomenting litigation. We can say that. That power we have.
Lordship, in the rule, Lordship, audit officer is not the only post, Lordship.
Hopefully after protecting them.
Audit officer is not the only post, Lordship. That law,
We are concerned with whatever is brought before us. We are concerned with that.
15 is not so ambiguous. 15 says year-wise vacancy, year-wise
No, no, no.
vacancy.
In all service rules, that is how it is. done.
One,
is not
17,
there.
3 is
Why
also
can't
there,
we read
Lordship.
that
They-
this
It
is
states, Lordship,
passive?
till the validity
Or
of.
giving you more controlling power. आप डिसाइड करेंगे कि कब हम एग्जामिनेशन करेंगे, कब वैकेंसी नोटिफाई करेंगे, and you don't notify the vacancy, which is very rare. I mean, how can it be justified? We don't know.
Precondition.
The lordship is
Then
between-
at what stage do you decide to hold examination? And what would the commission say? Commission will only talk about the contents of the examination paper
Yes.
and how they will conduct it.
They
But,
only
but what
conduct
is
the
what is the rationale for you to decide that yes, we are holding the examination now?
Because they'll have their vacancy.
The
That is
vacancy
condition.
accrues,
Lordship,
and you must be
we
keeping a
consider
threshold.
the new eligible candidates.
We will say that this is the stand of the department, and we find this to be absolutely unworkable. This is tentative. We might.
But that is in fact what we have decided, Lord. What your Lordship is saying, that we have decided, 1 year. If, that is why I am repeatedly saying, Lordship will understand. Lord, this rule has always been interpreted.
Every year you
there-
will hold examination.
Lordship?
Every year will you hold examination? Do you assure?
No.
Then?
No, that is not there.
Then-
I am saying, Lordship, since
Then Mr.
last
Mr.
one was in 2018.
If we will take your statement on record, and we will say that Mr. Nayak says that we will enforce this 1 year rule, but we shall not hold examination every year. We will set it aside. This is
Lordship, one is general provision, Lordship, my understanding, and one is particular provision.
we will ask for an
That general provision applies to other
we will
posts.
ask for an affidavit from the personnel department.
Lordship.
You clear your stand. It will be very easy for us to decide that this rule is unworkable. Absolutely clear. And we can quote examples from all over, all service, all states, all jurisdictions.
Lordship, that is why I'm and today.
So
I-
therefore
Three judgments,
your
Lordship,
stand
which
is very,
states-
very contradictory.
Even if it
You
is.
say that we will give complete effect to 20 subclause 3, but we shall not hold examination at a regular interval. We will not notify the vacancy. It depends. Even if there is one vacancy, we can hold examination, or the vacancy will accrue to 50, then we will decide. If you keep it so ambiguous, so vague, we would be perfectly entitled to enter into that
I
domain.
will try to satisfy your Lordship.
All right. So next date, sometimes in April.
Am I right, no?
You rightly said. Code of conduct election, nothing is going to happen, but we are not happy with these rules. We will take your statement on record and then decide. Arguments to continue. Take it.
মই এটা কথা কওঁ।
Item 1.
What do you have to say about the delay? We condone the delay, we'll hear it on merits.
My lord.
We condone the delay. Of course, it's 640 days.
No, my lord, 692 days, my lord.
So 50 days more this way or that way, we'll decide.
Without any proper explanation, my lord,
The question is that review, we must allow them for the reason. Of course, you're right. Let's see. We'll decide the review. I mean, if you're ready, we will hear the review now. We'll condone the delay, hear the review.
my lord, regarding my lord,
तैयार हैं आप? Are you ready?
any other day, my lord, final hearing for review.
Mr. Khatniar, are you ready? Because we don't find that you have any case for review. We'll condone the delay and we'll give you our own view.
Next week, any date, my lord.
Why not today? Let's be done with it. नहीं है, नहीं तैयार है तो we will not force you. लिखिए the delay condoned, the review petition to be listed under the appropriate heading. On which day would you be available? Next week. At 4. Anytime next week. Next week के next week कर दो. After review कर दो.
Review too, it will be April. But it's not after review. One review to April.
First week of April. Wait, तो बीच में हम जाएंगे तब.
First week of April.
8th of April.
My lord.
Give the details, Guranjit, for the reasons here. All right.